in 2021. After granting approval, they came out with
No,
another.
what is the urgency?
It's a minor, my lords, he's a minor.
All right, these are all facts of a case.
Lords, he's not even.
You have to tell us what is the urgency that we should list it out of turn.
Lords, since he's a minor and Lords.
Merely because somebody is making a mention.
No, Lords.
This is what happens. In other cases, there is no mentioning. So those cases should not be taken up. That is not the law. Unless there is some urgency, please do mention.
This is also 2022 matters, my lords.
So it will come. We have cases coming from 2013. You are seeing it, Mr.
My lord mentioned to the case, my lord, issued by the certificate by Magad University, my lord, lordship already has been directed, but till today certificate is not issued, my lord, university, my lord, urgent matter, my lord.
Certificate for?
Yes, my lord.
What is the certificate you are asking for?
BSc Math 2001 का मैटर है। अभी तक हुजूर का डायरेक्शन भी हुआ था, एक बार डायरेक्शन भी हुआ, उसके बाद टिल अभी तक कोई सर्टिफिकेट इशू नहीं किया।
तो अब हम क्या करेंगे जब हमारा डायरेक्शन ही नहीं माना? What else do you expect from this court? Apart from passing orders? Or you file your what you say as contempt petition, MJC?
No, my lord.
No, I'm saying either you do that.
My lord, हुजूर उसमें order.
My lord, this is for DLED exam, holding the DLED examination. My lord, the respondent board has conducted the DLED examination, main examination, and a lot of students have failed. They are not conducting the supplementary examination, and my lord, they are in job. Most of the students are in job. And what is
DLED by whom?
DLED by Bihar School Examination Board, my lord.
It's a fresh matter.
Fresh matter, my lord. In fact, counter affidavit has been received by the board. They are saying that we are not going to. They have mentioned in their advertisement only that they are not going to take re-examination or supplementary examination. But my lord, this is the right of the students. A lot of students are affected, and the examination were conducted even after.
We will see.
My lord, one opportunity, my lord, given. To me,
I seek permission to mention a case, my lord. My case is fully covered by the full pen decision, my lord, passed in Kalpana Rani versus the state of the case. So in the light of that case, my lord, my case may be disposed of, my lord. So it is a matter, my lord, that I was appointed as a Shiksha Mitra.
Have they agreed? Has the other side agreed that it can be disposed of by a full bench judge?
My lord.
No. That is the entire
matter is, my lord.
You will always say that it is covered by a full bench judgment. Let them also say.
I am able.
We will examine it. No? We will have to examine. It is not that easy. Sorry. Yes.
इसको 19 का केस है हुजूर, डिसमिसल में डर है।
हुजूर उसमें इंटरिम ऑर्डर।
No permission. Sorry.
My lord, इंटरिम ऑर्डर हुआ था हुजूर, फाइनल ऑर्डर हुआ
नहीं। No permission. Sorry.
फाइनल ऑर्डर नहीं हुआ।
Page wise. From the list, we'll just have.
Mention your lordship. This case is relates to termination, lordship. Petitioner appointed as panchayat teacher, or this case is squarely covered by the judgment of division bench, lordship, in LPA number.
When were you appointed as a panchayat teacher, and when were you terminated?
Appointment, lordship, 2006, lordship.
When were you terminated?
Termination, lordship, 2019.
The writ petition pending since 2019?
No, 2021, lordship.
Why have you not gone to the district appellate authority?
उस समय lordship, district appellate authority functioning.
Then we will get it listed and send you to the district appellate authority. You get it decided there within 6 months or 8 months.
On court के orders, lordship, similar petitioner.
So show that judgment there. Show that judgment to that district appellate authority. They will comply with the order. If it is safe, that is the only thing part to be examined. No? Even we will be examining that aspect. What do you say? You want it to be listed, to be sent to district appellate authority?
Instruction ले लेते हैं।
We will pass on orders.
My lord, read is pending, my lord, before lord.
Madam, I have already rejected your application. Please don't insist.
Madam, the list, my lord, item number.
Page wise. Item 1 to 15.
My lord, item number 10, my lord.
10.
My lord, I may be permitted to withdraw this application.
Council prays to withdraw the petition, dismissed as withdrawn. Any other mentioning up to 15? From 15 to 47?
My lord, 34, 4 weeks time may be granted.
4 weeks time. But why do you want 4 weeks?
My lord, the council who is appearing, my lord, his daughter marriage is there.
All right, 4 weeks. Adjourn.
Much obliged.
Lordship, 47 Lordship.
47?
Lordship, I want 1 week time.
1 week time granted.
Obliged.
48 to 79. Any other mentioning? Up to 80. Let's take it.
To be mentioned, item 1, Mr. Vijay Bhushan Prasad. Suresh Ram, enlightenment.
Lord, I have mentioned in this case on the ground, my Lord.
In terms of Suresh Ram, we decided?
My Lord.
You want it to be decided in terms of Suresh Ram?
My Lord, in one of the case, Anup Kumar case, I have annexed the order, my Lord. Petitioner is a teacher. He has been directed to stop work in light of the annexure 4, that is at page 20, my Lord. And he, along with other teachers also, other teachers move before this court, my Lord. And that writ application has been disposed of in terms of the order dated, my Lord, 28/1/2022. The impugned action has been set aside by this honorable court, my Lord, and direction was given to the writ petitioners of that case to para 8-9. My Lord of this.
You agree? Same?
No, he appointment
This
has...
judgment which has been passed, which he has handed over, have you given him a copy?
My Lord, I shall pass.
Well, you should bring at least
But
a copy.
this termination, इस petitioner का termination भी हो चुका है।
वो जो same issue
हुआ था इनमें जो केसेस हैं, ये जो पिटीशन फाइल हुई है जिसमें डिसाइड हुआ है कोर्ट ने.
I am not aware with that judgment, but so far this case is concerned.
All right.
Its termination है.
annexure 4 में देखा जाएगा वो जो
Annexure 4 में petitioner है.
हाँ गौरी शंकर प्रसाद, रंजना कुमारी, अंशु कुमार, शंकर इस्लाम, जैमुन निशा, all have moved before this honorable court in that writ application, my Lord. And
कब हुआ ये?
28 को उनके केस ऑफ
काउंटर तो आपको मिला ना मेरा? काउंटर 14/12/20 का है, तो वहाँ फाइल में ओरिजिनल यहाँ थोड़ा है. जरूर हुआ हो. करना पड़ेगा ही. ये ना गौरी शंकर प्रसाद
जी गौरी सर petitioner जी, इस सब का
कब का जजमेंट है?
28/1/2022 का, और हम 19 का केस है.
ये सब लेटर ऑफ टर्मिनेशन नहीं चले हैं. दिस लेटर इज नॉट अंडर चैलेंज.
The petitioner, by way of this petition, challenges the action.
My Lord, in my counter affidavit,
of terminating his services based on a vigilance inquiry, which and relying on a judgment passed by this court in case of Anup Kumar and others versus State of Bihar, TW 13370/2019, decided on 28/1/22. Learned counsel for the respondent submits that the facts of the said case were are distinguishable. Question regarding the termination of a Niyojit teacher can be examined by the concerned district appellate authority. The authority can also examine whether the case stands covered by a judgment of this court or not. In view thereof, the writ petition is disposed of with liberty to the petitioner to approach the concerned district appellate authority, who will examine the case on merits on an appeal filed by the petitioner. The same should be decided expeditiously.
Item number 2, it is wrongly listed. Item number 3.
Item number 2.
Wrongly listed. Item number 3, Mr. Shri Prakash Srivastava.
हुजूर ऐसे तो डिसमिसल है, टर्मिनेशन ऑफ टीचर का हुजूर, लेकिन हमारा प्रॉब्लम ये है कि जो ट्रिब्यूनल अभी काम नहीं कर रहा है। ये सर मधुबनी का हुजूर केस है, वहाँ ट्रिब्यूनल काम नहीं कर रहा है।
तो
न्यू अपॉइंटमेंट हो गया और
नहीं, अपॉइंटमेंट अभी नहीं हुआ है
और तीसरे जिला में हो गया।
तो हमारा टर्मिनेशन जो है, इसको अगर सुन लिया जाता है जो भी
petitioner has already challenged, has challenged his termination. The same can be examined by the concerned district appellate authority in view of Sureshan. The writ petition is disposed of with liberty.
Item number 4, Mr. Mrityunjay Kumar.
State appellate district, same. Petitioner challenges the selection, his non-selection on the post of panchayat teacher. कब का सिलेक्शन ही
2022 में हुआ
डिस्ट्रिक्ट appellate.
Item number 5, Mr. Karamdeep Kumar.
Late figure. On 22/7/22, my lord had directed rule returnable within 8 weeks. No counter has been filed by the IGNOU, my lord. We only wanted an upgraded grade card because the grade card that had been uploaded and which was furnished to us did not carry the marks with regard to EAOS 204. Now, my lord, even the regional director had issued a letter by virtue of annexure, page 21, my lord, asking the student evaluation division of the IGNOU, my lord, to update the grade card of the petitioner, my lord. And because of this, that
Who
now
appears for the NIUS? This is NIUS,
IGNOU, my lord.
IGNOU.
IGNOU, my lord.
Who appears?
Mr. Kanak Verma.
No reply.
My
No.
lord.
Then why do you get it listed?
My lord, for the reason of this IA application that we have filed, my lord, because now they have considered us to be untrained teacher, and now they have issued this letter directing that I should be considered as untrained, and by virtue of the order that has been passed by this honorable court. Now for
That we have said.
no, my lord, I have cleared the exam, my lord. Now I am already trained in the year 2010-12. Now only because of the upgraded mark sheet that they were supposed to furnish, they have not.
You arise out of your slumber, so after so much time, in 22 you have filed.
Lord,
with regard to a result of 2000.
While in service, my lord, while in service, we have been upgraded. My lord, will kindly consider the IA application, my lord.
For what? The NIA has been filed. Counsel for the respondents may file their reply to the same. Just after 4 weeks. Who appears for the state? Is there anyone, have you served notice on the state?
No, my lord. The state is not a party to this.
Then this order is relating to the order.
We'll have to add them as party. I'm sorry.
So then what should I say? Then the IA, you withdraw with the filing of a fresh?
My lord, we'll file an application for IA application for implement of the state as well as
counsel appearing for the petitioner. वो काट देना पहले वाला. prays for time to implead the state as a party in view of subsequent orders passed by the state police, granting liberty, list this case after the IA is filed. Amended cost title के साथ IA लगाइए.
Malad, we will do that, Malad. Malad may direct that the IGNOU may file the counter affidavit.
We will direct for listing of the case.
Item 6, Mr. Shanat Kumar Mishra.
My mark sheet contained one anomaly that in numerals it contained 522 marks, whereas in the words it was 418. And I had applied for correction and it was not corrected. The receipt is annexed to Lordship. Subsequently, it was corrected. I was selected for the.
Subsequently, it was corrected as 522 or 518?
418.
So it was corrected as 418?
Yes.
Whereas it.
But prior to that, prior to the correction, I had applied and I was selected for the block teacher, Niyojit Shikshak. And a vigilance inquiry was conducted, and it was said in the FIR that on the basis of post mark sheet I have been selected, and I was stopped from working. That's why I filed this. I was granted bail, and I filed this writ petition. They were asked, the respondents were asked to file their response. The DPO has filed his response that on the basis of the same, that the mark sheet was posed, I was stopped from working, and now he has directed the block employment unit to terminate my service. I filed the IA number 1 of 23 to prevent the authorities from terminating my service.
Mr. Counsel, one thing we want to know. The mark sheet was corrected by the board? Where is that corrected mark sheet?
That was obviously after the selection and.
But have you placed it on record?
That is, Lordship, that is on the record, Lordship. Annexure P1, page 13. Actually, inadvertently, the original mark sheet could not be placed, which contained both the marks, 522 as well as 418. But this is the correct marks, 418.
Which one? Page?
Page 13.
Where is that correction done?
I had applied.
Where do you say that it is a corrected mark sheet? This seems to be
at page 18, I had applied for correction.
Corrected mark sheet नहीं लगा है.
Where does it mention that it is corrected mark sheet? Or the date of issuance of this mark statement?
Yes.
Something should be there, no? From annexure 1 to difference in marks and college.
Yes.
This you had.
That mark sheet was, by mistake, it was left. Otherwise, I was to
place it on record. Then you can see your pleadings have to be complete, and that should be shown from your. And if it is 418 marks, then you are not in merit to be appointed at that time.
A person lesser than me, lesser than 418 was also selected.
So that saves you.
Yes.
So bring all those facts on record.
That I have already stated. I have already stated that a person having lesser marks was also selected.
Show which para?
Gotcha. para 12 of the read. Para 12, page 70. That in fact in the village all people know each other and it was widely known that the selection would be made at a much lower cut-off marks lesser than that obtained by the petitioner and one person, namely Sunita Kumari.
What is the counter?
The counter affidavit is filed, my lord, on the basis of the petitioner was appointed on the basis of
518 marks.
522 marks.
522 marks.
2 marks.
Why? That mark sheet did not contain 418?
No, my lord. He at the time of appointment, he filed a mark sheet. Yes.
Place that document on record. Yes. That original mark sheet.
Yes.
Which mentions 418 in words.
Yes. It is with me.
Please place it. Yes. So that he may also.
Yes.
He may be able to ask his officers and make his arguments accordingly.
My lord, on the basis of PIL, my lord, the first information report was
that we have. I don't know whether in PIL orders could have been passed relating to service matters.
But the inquiry was conducted
with
from
Supreme
the
Court orders strictly saying not to entertain PILs relating to service matters. Patna is different.
सीरियल नंबर 5 में हुजूर हम आइए पार्टी इम्प्लीट के लिए ही
There is the question of your case being taken up. Have you called?
नहीं हुजूर उसमें नहीं हो प्लेस नहीं हो पाया आइए हम हुजूर पार्टी इम्प्लीट के लिए ही फाइल किए हैं और ऑर्डर हो गया है कि आइए फाइल करने के लिए एक्सेप्टेड हम आइए उसी के लिए फाइल किए हैं सीनियर हुजूर बोले हैं कि बता देने के लिए कोर्ट को इसलिए
तो आप उस समय क्यों नहीं बोले? एडजर्न कर दीजिए कुछ भी ऑर्डर काउंसिल फॉर टाइम टू फॉर लिस्ट अगेन आप
तो इसको कल के लिए तो कर दिया जाता है मेंशन करके मांगे
प्रॉपर्ली ब्रीफ नहीं करेंगे सीनियर को बोलेंगे है नहीं कोर्ट में आगे रख दीजिए नेक्स्ट वीक की डेट दे दीजिए
रिटेनिंग एक्सपोजिशन कर दिया जाएगा
चलिए
रिटेनिंग एक्सपोजिशन
Item 7, Ajay Kumar Chakravarti.
Matter, Lordship, relates to arbitrary withholding of the salary of the petitioner, Lordship. The salary withheld by Annexure 1, Lordships, at page 13, when surprise visit made by the DPO on 31/12/2021, Lordships, in absence of petitioner, my lord, who was on her special leave में था उस दिन वो. The DPO asked her to bring all the school registers, including the MDM registers, in the office, in order to stop salary payment to the salary to the petitioner.
After that, you have been paid salary?
No, my lord.
After January 2020, you are being paid?
The salary has been paid.
You are only claiming salary for a particular period, no?
5 months salary has been later on paid.
From this part, you go to the District Appellate Authority.
Each survives 20 to 20.
The petitioner prays for claiming salary for the period from December 2019 to January 2020.
21. Last two weeks.
Aspect can be adjudicated and examined by the concerned District Appellate Authority. The petition is disposed of with liberty to file appeal before the concerned District Appellate Authority.
Lordship, by page 20, 7 lakh salary has been paid for 2 years, prepared for 3 years, and still it is not been paid, Lordship.
आप तो कह रहे हैं
एक जनवरी ये कह रहे हैं कि जून सिर्फ 20 का में तो जून 6 महीने का पेमेंट कर दिए फिर स्टार इसे रोक दिया है जिसका कि पेज 20 पर है 7 लाख रुपया स्टील आज टर्न टुडे 2 साल से पैसा बना के पेमेंट नहीं कर रहा दिस पेज 20 इज देयर लॉर्डशिप्स तो 2 महीना का ओनली 3 पेमेंट कर दिया इसके बाद पुनः विदाउट नोटिस इट हैज बीन स्टॉप्ड that is all prepared at page 20. This amount has still been not being paid and I am on duty, Lordships. 7,65,000 up to date. up to 23 Lordship, 203.
देखिए, the petitioner prays as under. In Pallavi Kumari, उसका judgment दीजिए. This court has held as under. Keeping in view thereto, the respondents are directed to release the salary in terms of the aforesaid direction within period of 2 months, along with interest. The same shall be interest at the rate of 9%. The same shall be recoverable from the concerned officer who has not released the salary. That petition stands allowed.
Item 8, for admission 1, item 8. Mr. Shashi Shekhar Tiwari.
Lordship, kindly turn to page 82, Lordship. Matter relates to appointment against class 4 post, Lordship, by the petitioner, Lordship. On that very day, it is on 11/10/17, 2 kinds of order has been passed, Lordship. जो देखा जाएगा नेक्स्ट 10A से पेज 82 पर जी जी, ये हुजूर देखा जाएगा ऑथर जिला शिक्षा पदाधिकारी रेस्पोंडेंट नंबर 7 मेमो नंबर 10 10A लॉर्डशिप
10A
लॉर्डशिप
पेज
82 लॉर्डशिप नेक्स्ट पेज देयर लॉर्डशिप सो एंड सो इट इज प्रेषक जिला शिक्षा पदाधिकारी टू सेवा में निदेशक जन शिक्षा सो एंड सो विषय देयर कि समूह में PC2 के रिक्ति अनुपलब्ध होने के कारण एक अनौपचारिक शिक्षक अनुदेशक का प्रस्ताव वापस करने के संबंध में बस ये हुजूर उपरोक्त विषय ऊपर में सर्टेन लेटर्स आर इम्पोर्टेंट बस
अनौपचारिक शिक्षा निदेशकों की सूची उपलब्ध कराते हुए
जी जी
पढ़िए
ऊपर में है हुजूर उपरोक्त विषय भौतिक पत्रांक 21 दिनांक 21/17 के आलोक में माननीय उच्च न्यायालय द्वारा पारित आदेश के अनुपालन हेतु मध्य प्रदेश जिला अंतर्गत 63 अनौपचारिक शिक्षा अनुदेशकों की सूची उपलब्ध कराते हुए जिला अंतर्गत माध्यमिक विद्यालयों में समूह की उपलब्ध रिक्ति के विरुद्ध माध्यमिक विद्यालय विद्यालय उपलब्ध रिक्ति के विरुद्ध विभागीय संकल्प संख्या 945 दिनांक 27/4/17 इट इज हाईली रेलिवेंट लॉर्डशिप के निर्देश में समायोजन हेतु प्रेषित निर्देश के आलोक में 62 अनौपचारिक शिक्षा अनुदेशकों द्वारा आवेदन फोल्डर एवं संगत अभिलेख समर्पित किया गया के क्रम में 61 अनौपचारिक शिक्षा अनुदेशकों का समूह के पद पर संयोजन अक्षर और शब्द अनुसार बिंदुवार निम्नलिखित की गई. दिस वाज द वे ऑर्डर आफ्टर लॉर्डशिप. देयर आफ्टर लॉर्डशिप myself is a BC female, BC2 female. It is serial number बॉटम से हुजूर देखा जाएगा 2 पोस्ट था वहाँ पर भौतिय द्वारा उपलब्ध कराया गया 63 अनौपचारिक अनुदेशकों के BC2 के कैटेगरी 10 अभ्यर्थी थे. समूह के उपलब्ध रिक्ति के आरक्षण बिंदु के आधार पर BC2 के कोटि अंतर्गत मात्र 9 रिक्ति उपलब्ध रहने के कारण उक्त कोटि के 9 अनुदेशकों का संयोजन वरीयता के आधार पर किया गया. एक अनुदेशक किरण कुमारी दैट इज पेटिशनर लॉर्डशिप अजय प्रसाद स्टूडेंट जन्म तिथि स्टूडेंट इंटर स्टूडेंट समूह के पद पर संयोजन नहीं किया जा सकता. हालांकि ये गलत स्टेटमेंट है क्योंकि NXR 6 संप्रदाय में मेरा अपॉइंटमेंट भी हुआ है, NXR 7 से हम वर्क भी किए हैं. अतः भौतिक से अनुरोध है कि माननीय न्यायालय के पारित आदेश का अनुपालन की दिशा में किरण कुमारी स्टूडेंट BC का अन्य जिले में उपलब्ध रिक्ति के विरुद्ध संयोजन की दिशा में समयोजित निर्णय लेने का कष्ट करेंगे हुजूर. ये मेमो देखा जाएगा 517 डेट देखा जाएगा हुजूर 11/10. यह अन्य जिला कर रहे हैं, अन्य डिपार्टमेंट नहीं कर रहे हैं हुजूर. देयर आफ्टर ऑन सेम डे ये मॉर्निंग सेशन में ये ऑर्डर होता है हुजूर और इवनिंग सेशन में देखा जाएगा पेज 81 एनेक्सर 10. यथोचित निर्णय लेने के लिए ये भेज रहे हैं डायरेक्टर को मॉर्निंग में और इवनिंग सेशन में कह रहे हैं निदेशक जन शिक्षा विभाग स्वयं के आलोक में विभागीय पत्रांक संख्या 945 सेकेंड 945 इज वेरी रेलेवेंट लॉर्डशिप. कंडिगा के निदेशक के रिक्ति की अनुपलब्धता की स्थिति में इस कार्यालय के 500 द्वारा किरण 500 या 500 BC के कोटि संशोधन की योगेंद्र उच्च विद्यालय मुरहन में दिनांक 500 के पद पर समायोजन नियुक्ति की उक्त तिथि से निरस्त किया जाता है. दैट दे कैंसिल. मॉर्निंग में ये प्रस्ताव मांग रहे हैं निदेशक से हुजूर और इवनिंग में सेम अथॉरिटी दैट इज रेस्पोंडेंट नंबर 7 मेरे अपॉइंटमेंट के बिना किसी तरह की शोक की बिना किसी तरह के प्रोसेस अडॉप्ट करके ये हमारा कैंसिल कर दें. अब आया जाए ये 27/4/17 का जो लेटर है उसको देखा जाएगा. हमने एनेक्सर किए हैं. एनेक्सर 11 है पेज 83 रनिंग पेज 83 पर है. ये जनरल नेचर का डेट है. आपको प्रोसेस एडॉप्ट आपको एक पैनल बनाना है, आपको रोस्टर फॉलो करना है एंड दैट वेरी रोस्टर लॉर्डशिप काइंडली टर्न टू पेज 176 लॉस। इनके सप्लीमेंट्री का हुजूर, सप्लीमेंट्री काउंटर का हम रिप्लाई फाइल किए हैं। रनिंग पेज 176।
176
जी जी पेजिनेशन है हुजूर।
रिप्लाई टू द सप्लीमेंट।
जी जी उसमें रेलिवेंट पेज है 176 प्लस 176। माननीय सर्वोच्च न्यायालय नई दिल्ली
काउंसिल दैट स्टार्ट्स फ्रॉम पेज 176।
जी हुजूर मेरे रिप्लाई का लास्ट, मेरा रिप्लाई सॉरी इट इज आईए नंबर 2 लॉर्डशिप, आईए नंबर 2 ऑफ 2022 का लास्ट पेज बस। जी जी माननीय सर्वोच्च न्यायालय नई दिल्ली पटना द्वारा पारित आदेश के अनुपालन में सामान्य प्रशासन विभाग बिहार पटना के पत्रांक 16/371 दिनांक 13/12/19 दिस लेट और डेट इज ऑल्सो रेलिवेंट लॉर्डशिप के द्वारा समायोजन क्रम में आरक्षण प्रावधानों के पूर्ण अनुपालन किए जाने संबंधी पत्रांक 945 दिनांक 27/4/2017 जो हम रेफर कर रहे थे, जिसको इनके प्रावधान में प्रावधानित शर्तों की आंशिक रूप से शिथिल करते हुए जो ओरिजिनल लेटर था वो जिससे कि रोस्टर का इनको कंप्लायंस करना था, उसको आंशिक रूप से पार्शियली ये जो डाइल्यूट करते हैं, रिलैक्स करते हैं। अन्य मामलों में पूर्वधारणा नहीं मानी जाने की शर्त पर आरक्षित वर्ग BC2, BC1, SC के अनौपचारिक शिक्षा अनुदेशकों का संयोजन एक बार के उपाय वन टाइम मेजर के रूप में गैर आरक्षित वर्ग अनरिजर्व जनरल से प्राप्त रिक्तियों के विरुद्ध किए जाने का निर्देश दिया गया है। भविष्य में संबंधित आरक्षित वर्ग से में रिक्तियां प्राप्त होने पर इस गैर आरक्षित वर्ग को उपलब्ध कराते हुए समायोजन किया जाएगा। That very letter was very genesis for adopting the genesis lordship that has been relaxed lordship, and the effect of that relaxation is at page 175. जस्ट उस ऊपर वाला लेटर दिखा जाए और उसी ये लेटर का ये अपर पार्ट है हुजूर। ये कॉलम सेकंड लास्ट कॉलम देखा जाए और लास्ट कॉलम देखा जाए। ये 4 लोगों का अपॉइंटमेंट हो रहा है हुजूर। सेकंड लास्ट कॉलम में अनुदेशकों की वास्तविक जाति कोटि ऑल आर BC2 लॉस एंड निम्न जिस कोटि के पद के विरुद्ध अनुशंसा की जा रही है हुजूर, ये हुजूर ऑल जनरल्स सारे BC को ये जनरल में लिख रहे हैं। कर लिए 2000 रूल उस लेटर को रिलैक्स कर हमको BC1 से BC2 में कह के आज की डेट में हमको बाहर रखे हुए हुजूर। वो एक उनके पास एक दुविधा हो सकती थी हुजूर नवंबर 2019 में, क्योंकि नवंबर 2019 में वो लेटर नहीं था, वो रिलैक्सेशन वाला लेटर हुजूर दिसंबर 2019 में आया। नवंबर में वाले में नहीं होने के चलते ये हमको पूर्णिया ऑफर किए थे, क्योंकि हमारे हम रिकॉर्ड पर लाए हैं, हमारे हस्बैंड बेड रिजन थे, वो टीचर हैं, वो उनका डेथ भी हो गया, ब्रेन अटैक हुआ था, रिकॉर्ड पर है जो, जिसके चलते हम नहीं जा सकते। हम रिक्वेस्ट करें कि हमारे किसी भी डिस्ट्रिक्ट, क्योंकि ऐसा नहीं था कि किसी एजुकेशन डिपार्टमेंट हमको रखना था, किसी भी डिवीजन में किसी भी डिपार्टमेंट में ये हम रख सकते थे। उन्होंने डिसीजन नहीं दिया, इसलिए रिलैक्सेशन आया है। और हुजूर पिछली डेट पर हम रिकॉर्ड पर जो कि लगा भी है, बिल्डिंग डिवीजन की हम बात की, क्योंकि हमको जानकारी नहीं थी कि हमारा पोस्ट शायद वहाँ पर भरा जा चुका हो। अभी भी वो पोस्ट उस स्कूल में अभी भी खाली है हुजूर, और उसी रिलैक्सेशन की वजह से वही हुजूर आज के डेट में लेटर क्वेश्चन होने लायक है और इनको डायरेक्शन होने लायक है हुजूर, तो हमको वहीं पर ज्वाइन कराया। मेरे हस्बैंड आज के डेट में सर्वाइव भी नहीं कर रहे हैं, आज की जरूरत में हुजूर समय में आज मेरी और जरूरत जगह पर है हुजूर। पूर्णिया यहाँ से लगभग 100 से ज़्यादा किलोमीटर हो जाता है, एक तरफ से 100 किलोमीटर, एक तरफ से दूसरी तरफ से 100 किलोमीटर हुजूर, समझा जा सकता है क्या डिफिकल्टी हो सकती है।
Where is that letter showing vacancy?
हाँ हुजूर, ये तो हम दिखा दिए हुजूर, जनरल से वो देखा जाएगा हुजूर। हम लास्ट एफिडेविट डेट पर एफिडेविट लाए थे, अदर डिपार्टमेंट में हुजूर है 195। हालांकि वीडियो क्या कलेक्ट कर सकती है, क्या एक्सरसाइज कर सकती है, वो देखा जाएगा हुजूर। 195 है, ये लेटर स्टार्ट होता है 195 से और 196 में। हालांकि मेरा रेस्पेक्टिव सबमिशन है हुजूर, कल हम काउंटर अपने मित्र को रिप्लाई डाल दिए हुए, ऑनलाइन फाइल है हुजूर, फिजिकल कॉपी शायद नहीं आई होगी। बहुत सारे डिपार्टमेंट में, इसमें हम बिल्डिंग डिवीजन का चर्चा किए हैं, मुझे पूरा में ही देखा जाएगा पेज 196 पर। समूह के अतिरिक्त दफ्तरी कोषागार चौकीदार कार्यालय परिचारी का 13 पोस्ट है हुजूर। कार्यालय परिचारी हम जो है ऑफिस पियून हमको होना है हुजूर, क्लास 4 में एडवेस वही हम हो सकते हैं। हम जो आज कल जो रिप्लाई हुजूर फाइल किए हैं उसमें वेटनरी डिपार्टमेंट में, वेल्डिंग डिवीजन में, एग्रीकल्चर डिपार्टमेंट में, हेल्थ डिपार्टमेंट, हर डिपार्टमेंट में कहीं भी अगर क्लास
फाइल सम फर्दर एफिडेविट समथिंग
फाइल कर चुके हैं, रिकॉर्ड पर नहीं है, कल ऑनलाइन फाइल किए हैं, उसको देखा जा सकता है। या फिर चूंकि मेरा स्पेसिफिक रिक्वेस्ट था कि वह जो रोस्टर कंप्लायंस का 2017 का लेटर था 2009
This is the one which has been filed.
जी देखा जाएगा इसमें एनेक्सर 1 सीरीज ये स्टार्ट हो रहा है।
You want to file a reply to this?
That requires to be filed. Earlier, he has filed a second supplementary affidavit that I have replied not by way of
filing. Second supplementary counter affidavit.
Lordship, इसमें जो हम कह चुके हैं, there is no post in Madhepura district.
वो वाला
another affidavit he has filed.
नहीं है, वो जो इनका जो सेकंड सप्लीमेंट्री है,
पहले का हम जवाब दे चुके हैं, उसमें कह रहे हैं
Counsel for the petitioner states that he has filed a reply to the second supplementary counter affidavit. Registry is directed to place the same on record.
तो मेरे मित्र का जो सेकंड सप्लीमेंट्री भी नहीं है, उसको भी डायरेक्शन कर दिया है। देखें नहीं, रिजनेशन नहीं करता। एक रिक्वेस्ट दिया था हुजूर, ये वहाँ भी पता कर लें, क्योंकि मेरा स्पेसिफिक एफिडेविट गवर्नमेंट है, अगर वहीं पर उसी विद्यालय में अगर वो पोस्ट खाली है, जब BC2 मेल जब जेंडर के अगेंस्ट जा सकते हैं हुजूर, तो BC2 फीमेल BC1 के अगेंस्ट जा सकते हैं हुजूर, इस पर भी इंस्ट्रक्शन ले लें। 55 साल की उम्र में इतना हरास करना, इतना इस तरह से मेरे मित्र लेने, उस पर भी
First decide when you want to argue finally.
लॉर्डशिप आ जाने दिया जाए, certainly proceedings should be completed.
And you complete your arguments. Whatever we have to pass, we'll pass.
नहीं पूरा आने दिया जाओ।
Item number 9, Mr. Rajiv Kumar Singh.
Lord Vanekshar, one is the order of State Appellate Authority, which is at page 11. आप क्या करिए सर, करना है, समझ लेना, खाली आंख है।
फाइल में गलत आ गया, दूसरा एडमिट आ गया यूनिवर्सिटी।
बोल दीजिए तो फिर कहाँ के लिए आगे बढ़े।
मिलर्ड
इम्पोर्टेंट रोल
मिलर्ड इसमें
You are challenging this order?
इसमें बहस लंबा होगा। हुजूर ने गलती से दूसरी फाइल मेरे पास, ऐसे स्टेट का कोई रोल है नहीं, हुजूर ने कॉस्ट किया था, हम दे दिया। अब इन बिटवीन पिटिशनर एंड प्राइवेट रिस्पोंडेंट का लड़ाई है इस केस में, स्टेट का कोई, लेकिन आज फाइल हमारी गलती से छूट गई, दूसरी फाइल आ गई।
Next week रखते हैं। Counsel for the respondent. State wants time. List again next Thursday.
Any date is
Next Thursday.
16 तारीख 16।
Item 11, Mr. Amresh Kumar Singh. Item 11, Amresh Kumar Singh. Item 11.
10 पास हो गया।
10 withdraw कर लिए, 10 withdraw कर लिए।
10 withdraw कर लिए।
Item 11.
Your Lordship, in this case, I've been instructed that the certificate has been issued now and he can go and collect it where it has been issued in the name of the petitioner.
Although, Your Lordship, I have talked today from his father, Your Lordship. He said that the certificate has not been.
Tell him to go today.
I have the certificate number also.
Where he should
share
go,
the details.
Where he should go? कहाँ बोलिए?
University. To the controller of examination, I have the certificate
Third
details.
counsel appearing for the university.
Yes, Lord.
States that the controller of examination has instructed him that the state of the petitioner has been already prepared and the same may be collected from the office of the university.
Yes.
Counsel for the petitioner may take steps. List this case again next Wednesday.
applied.
Ugly bench, you by that time you will be able to.
Because your lordship, the petitioner is outside.
अगले बुधवार तक के लिए रखें, आगे रखें.
2 week कर दिया जाए.
2 week.
वो दिल्ली में रहता है.
All right. 20th.
Okay.
23rd.
Item number 12. Mr. Vasisht Narayan Mishra.
Yes, what is your stand? What is your stand? You appear for the state.
State, but not this important order has been passed by Sanskrit Shiksha Board.
What is the stand? Because it's not.
Your lordship has dismissed several applications that this charger degree.
No, this is not related. Your lordship.
No, this is with regard to giving original certificate. You are appearing in which case?
It's 12, your lordship.
गलत आ गया?
जी.
You are appearing in item number 12?
Milos, I am in 12. Milos, this matter related with Milos, the Sanskrit Shiksha Board Milos. And Milos, about Milos, pay revision scale Milos.
Acharya?
जी.
And you want it to be treated as?
No, ऐसा नहीं.
For the purpose of training?
No. This is not a case, Milos. Milos, my case is that Milos, according to Milos 6th and 7th pay revision commission Milos, my scale was fixed Milos, by the annexure 5 Milos. In the scale of 49,000 Milos. And Milos, that was later on Milos, without giving any rhyme and reason Milos, has been cancelled Milos. That is Milos, kindly have a look Milos, your lordship Milos, that I have challenged Milos.
I will reply, especially to para 10 of this writ petition, that you have granted the scale but not paid. Reply be filed within 4 weeks.
Item number 13 with order case, Mr. Ritesh Kumar.
My lord, I am appearing on behalf of CWJC number 1013522, my lord.
On behalf of?
The first case is appearing, lord. In the first case, my lord.
We are taking up this case only.
My lord. इसमें ये कहना है कि हम इसको मतलब विड्रॉ कर रहे हैं एंटायर पिटीशन को, माय लॉर्ड.
ओके,
माय लॉर्ड.
काउंसिल फॉर द पिटीशन.
जो 1 मिनट बिफोर माय लॉर्ड.
So this order of transfer has been cancelled?
That is my lord, my lord, in the second case.
All right. This order
हो गया है, मतलब फर्स्ट और थर्ड तो नहीं किया है.
That order of transfer has been cancelled.
My lord.
Learned counsel for the petitioner submits that the order impugned, dated 4/6/22, whereby the petitioner was transferred from S.N. Sinha College, Aurangabad, to R.M.W. College, Nawada, as a principal comma, has already been cancelled.
Recall हो गया वहाँ पर.
By order dated?
Order dated 5/1/23. 5/1/23, my lord.
23. And you thereof, the writ petition has been, the grievance of the petitioner stands redressed. The same has accordingly become infructuous. Writ petition is accordingly dismissed as having become infructuous. Yes.
No, my lord, in this case, my lord, I am challenging, my lord, annexure 11, page 28.
एक और humble submission था, my lord. इस petition में एक petition का copy हमको receive करवा दिया. My lord.
Page 28, my lord. This is the order of transfer, my lord. औरंगाबाद का स्थानांतरण प्रशासनिक दृष्टिकोण से टीएस महाविद्यालय हिसुआ में तत्काल प्रभाव से कृपा प्रदान की। My lord has seen that.
This is the order passed, whereby you have been transferred.
Yes, my lord. But before proceeding further, my lord, I will invite my lord's attention to annexure 9, page 26. 2 पेज पहले भी। My lord has got it. इस 24/6 को हुजूर हमको यहाँ से annexure 9 से ट्रांसफर हुआ, सजदानंद सिन्हा औरंगाबाद में तत्काल प्रभाव से कृपा प्रदान की है। So by annexure 9, my lord, I come to this college
from
girls' college in Aurangabad. And then, my lord, by annexure 11, within a period of 6 months.
Now you have been transferred out.
Now, then 26/6, my lord, will to come to my rescue, my lord. And my lord's order, I have annexed, my lord, page 39. Annexure 14.
How much time you had spent in this girls' college Aurangabad?
4 years. वहाँ भी 5 वर्ष नहीं थे। वो भी 4 वर्ष थे, हम भी 4 वर्ष थे दूसरे जगह. And then they were transferred. But the twist comes now, my lord. By this order, my lord, I was transferred. I joined, my lord. But in the meantime, my lord, by order dated 4/6/22, my lord has had the occasion to see that order in the first case. He was transferred.
Which he challenged?
Which he challenged, my lord. Now, my lord, see. 4/6/22, my lord, if your lordship will turn to IA number 2. Thereafter, my lord, he joined there on 7th. 4/6 के बाद 7 को उन्होंने ज्वाइन किया, and that order was cancelled, my lord, recalled by annexure 1/7, my lord, at page 56 of my IA number 2.
IA number 2 is.
There are 3 interoffice applications. One, my lord, I filed an application for
IA number 2. Where is that order?
At page 56, my lord. IA का page 56. Yes.
IA का page. We have a running page.
No, my lord, I am sorry, my lord, I couldn't paginate.
It is also in the supplementary.
एक supplementary affidavit फाइल हुआ, उसमें भी है हुजूर, लेकिन of course, my lord, it should have been paginated.
All right.
My lord has seen.
All right. So
5/1/23, my lord, it is recalled. I have challenged this order. Why I challenge, my lord? Keeping in view the smooth functioning of efficient administration, so and so, dated 4/6 is hereby recalled. Dr. Ved Prakash is directed to assume the charge of the principal of SM Sinha College. हम वहाँ से आए थे हुजूर, अब वहाँ उन्होंने कर दिया, इसलिए हमको चैलेंज करने की जरूरत पड़ गई।
वहाँ किसको कर दिया?
इन्हीं को कर दिया ना, औरंगाबाद SM सिन्हा कॉलेज में जो हम थे, हम 6 महीना रहे यहाँ और उसका हमको ट्रांसफर कर दिया हसुआ। Whether that order is sustainable, my lord, in view of section 26, that is one part. Second part, my lord, whether once the order of transfer has been acted upon, it can be recalled or not. I will be referring to 2 judgments of this court, my lord. 2000 का 3 PHR 139 और एक है जो 9 का।
2003-4
2000 का 3 139 और एक है हुजूर there are other judgments also was my lord 2009 का 4 PL पेज 717 देखिए
Which order are you challenging now?
I am challenging, my lord, his transfer back to SN Sinha College.
But that
because, my lord, I am challenging first order, my lord, Annexure 11, and then, my lord, I am challenging this order because otherwise,
There is the amendment. Where is the writ petition challenging it all? That's it.
I file IA, my lord.
IA doesn't mean that it is challenged.
Amendment by way of amendment, I have straight for quashing of further reliefs. That is, my lord, I have said. If your lordship will see on the IA 2, उसमें हमने क्लियर किया है हुजूर. Application for the following release in paragraph 1. I have stated, my lord.
Lord, it comes first.
My lord, इसमें ऐसा है एक कॉपी
filed an IA. Where is your prayer for amendment?
That is, my lord, page 2.
Seeking
और एक हुजूर आपके हुजूर के ऑर्डर
amendment
रिलाई करते हैं
in the writ petition. Praying for quashing of orders passed by the respondents after filing of the writ petition. The counsel for the university may file a reply to the IA. What is IA 1/23?
One is for impleading without the private respondent proposed.
That has been allowed?
No, that has not been allowed.
Another IA has been filed for impleading one Dr. Ved Prakash Chaturvedi as party respondent number 5 to the writ petition. For the reasons stated, IA number 1/23 is allowed. Amended cost title be filed. Copy of the writ petition be made available to you are filing your filed a PV to the
अभी इसमें हम पार्टी नहीं माय लॉर्ड इसमें पार्टी बनाने के लिए भी
ये वेद प्रकाश चतुर्वेदी आप ही हैं
जी
also for the concerned respondent who may file his reply to the writ petition as well as the IA number 2/23.
My lord. In the meantime, Lord, may I pray, your lordship's order, my lord, may I pray for a stay of that. There are two orders, my lord. One I am challenging Annexure 11, my lord, and another order. And now they are taking a step, my lord, I filed with the president.
Examine that order. I don't have to tell you.
No, Lord, I don't say. What I say, my lord.
Your Lord,
put up.
Lord, may I say one thing only, Your Lord? The writ petition is having a remedy before the Honorable the Chancellor, Your Lord. There is a specific remedy, Your Lord, under the statute, my Lord.
File your reply.
इन्होंने फाइल किया उसका रिप्लाई मगर यूनिवर्सिटी ने दिया हमने काउंटर भी लगा दिया आगे केवल इनके
Now the transfer order has culminated into a private dispute. The matter may be referred to the Honorable the Chancellor who
how do you justify
pass order, my Lord.
if it is without jurisdiction how do you justify the recording of that
the first remedy would be available to the Honorable the Chancellor.
I don't tell you my lord has passed an order हमको एक हुजूर एक लिमिटेड प्लेयर है सब्जेक्ट टू माय लॉर्ड प्लीजर हमको जो अब एक्शन लेने को कह रहे हैं हमने पिटीशन फाइल किया है तो एक हुजूर इंटरिम हमको कोर्टिव एक्शन नहीं ले कुछ बस दैट्स ऑल आई डोंट सीक my lord the stay of that order or that order I am only my lord saying lady is there 200 किलोमीटर फर्दर ट्रांसफर इन्होंने कर दिया है 6 महीना
It is about 130 kilometers away, Your Lord. And may I suggest let it be posted Matter just after 2 weeks, Your Lordship. In the meantime, Your Lordship, I would be filing affidavit.
1 week का time देना.
Yes.
1 week.
2 weeks, my Lord.
Then you will not take any action against, no coercive action against the petition.
At least if it is only 2 weeks time.
Or London Council for the University wants 2 weeks.
अभी तक कॉपी भी नहीं मिला है कम से कम 3
No
weeks.
coercive action against.
नहीं तब फिर एक ही हफ्ता कर देते.
Coercive action की तो कह रहे हैं आप चार्जशीट मत देना भाई को. यही तो कह रहे हैं. No coercive action to be taken against the petition. However, this would not mean that the order has been stayed by this court.
Item 14, with analogous case, Mr. Shuman Kumar and Mr. Arun Kumar.
My Lord, may I please? This is for NOC by the state government. My Lord, subsequent to the last order on 30th November, the state government has conducted another inspection in the month of January, on 17th of January, and they are not giving the NOC till date, my Lord. Moreover, the National Council of Indian Medicine has rejected the application, although there is a order of your Lordship that the NOC requirement will not come in the way of applying, and it will be subject to the final outcome of this writ petition.
So they have rejected your.
Yeah, my Lord, they have rejected.
So that we challenge that.
I will challenge, my Lord.
You file a fresh petition.
My Lord, I will file a IA in that. Meanwhile,
that is for that might be on different considerations, and there is an appeal also provision against that rejection.
Yes, my Lord.
Then,
in fact, my Lord, your order was your Lordship's order was.
It was just that NOC might be, but if it is this ground,
my Lord,
then it is another thing. You take your own, take a call. How you have to do it.
My Lord, but
Council wants time.
NOC about from the state government, they have conducted the second inspection, my Lord, and a time should be given so that the NOC can be given by them. A time limit may be fixed within which, my Lord, in fact, 31st of March is the last day on which the NCSIM recommends to the central government for opening of the college. So the NOC must be there in this month only, my Lord.
Is your rejection on the ground that NOC has not been given?
Yes, my Lord.
That is the ground?
Yes, my Lord.
That is the only ground?
That is the only ground, my Lord.
The rule? You move in IA. You can move in IA before this.
My Lord.
London Council of the petitioner informs that due to tendency, the what is that authority?
National Council of National Commission for Indian System of Medicines.
National Commission for Indian System of Medicine has rejected the application for.
The application was rejected, my Lord.
For on the ground that NOC has not been done, has not been released by the Health Department of Government of Bihar. He may move appropriate IA for impugning the said order, if so advised. London Council appearing for the Government of Bihar. You have filed your reply?
Yes, ma'am. My Lord, in fact, after filing their reply, they have conducted another inspection, my Lord, on 17th of January. So now, and all the shortcomings have been removed. So NOC must be granted, my Lord, there.
What do you
the time
say?
limit may be fixed.
On that ground, supplementary affidavit, that order has been brought on record, my Lord. For that 2 week time may be granted.
The Government of Bihar can't be there. It is it's further stated by London Council for the petitioner that a second inspection has already been conducted by
On 17th January, my Lord.
Government of Bihar
Government of Bihar.
representatives on 17th of January 2023 and after inspection all the deficiencies have been found to have been removed. The inspection report has been placed on record.
Submitted on 20th January, my lord. 20th January.
You have placed it on record?
My lord.
The inspection report of 20th January has been placed on record. Keeping in view the inspection report, the respondent's government of Bihar is directed to pass orders regarding release of NOC within period of 10 days.
2 weeks.
And submit the copy of the order before this court, before the next day, list after 2 weeks.
I'm not maintaining this position, my lord. Oblige me.
In both the cases, it's the same.
In the same case, your lordships, during pendency of the writ petition, your lordship, they have pointed out certain.
Why do you get these cases tagged like this?
Initially, your lordships, it was because the similar matters of Ayurvedic was there. The further proceeding was not.
ऐसे तो कई cases होंगे आयुर्वेद के. Can't get them tagged.
No, your lordships, because on that very day
there is no reply. No
reply has been filed by the.
इसको separate कर दो. Counter may be filed on behalf of the respondents. 3 weeks.
Copy sir किए हैं.
Item 15 with analogous case.
My lord, in light of the order dated 18/1/2022.
How are these analogous cases?
My lord.
Why are there 4 cases? All of them are same?
In one case, my lord, item number 15, I am for the state, my lord, and pursuant to your lordship's order dated 18/1/2023, I am supposed to file, my lord, my reply to the IA, but it could not be filed, my lord, so as a last indulgence.
Council wants time to file reply to the IA. 1 week further time is 10 days further time is granted, list after 2 weeks.
Much.
ये क्या है? दूसरे केसेस क्या है?
Item of 15.1.
किसने लगाए?
Mr. Kumar Kaushik.
Yes, Mr. Kumar Kaushik, why is your case listed along with this?
It seems to be the same cause of action. The petitioners were appointed on contract basis in Bihar.
They are all challenging the same order?
It is not the same order, but my lord, they filed the writ application for.
The cause of action would arise from a same order.
Yes.
Not different orders.
They are all same employees.
A reply has been filed?
In this case, pleadings are complete.
Complete. Please this case again for hearing. Pleadings are complete. Separate कर दीजिए इसको. Card दीजिए.
Item of 15.2.
कब गए
After 4 weeks कर दीजिए.
15.2. Kumar Kaushik.
Yes, in this.
These 2 cases in which I appear, they are the same. In both cases, pleadings.
Same cause of action. Same order challenge.
My lord, same order.
Then why 2 petitions?
My lord, both were filed after an interval. The rest of the petitioners had come later, therefore.
All right. तो इसको इसके साथ देखिए. 15 point. इन दोनों एक साथ हो जाएंगे. एक ही डेट हो जाएगी.
15.3. Mr. Rakesh Kumar Sharma.
They may be heard sooner than 4
Yes,
weeks.
what is this case?
Since my lord, all
We
of
have
them.
already passed order.
15.3. Mr. Rakesh Kumar.
In this case, the pleadings are complete, my lord.
So what is this case?
My lord, this is with regard to merger of the petitioners in the subsequent, the successor organization, Bihar Education Project Council.
First and fourth both have the same
First
issue.
and the fourth have the same issue.
Same issue. First and fourth both have the same issue.
But they are separate. This is what something other claim or same claim?
Same claim. By
They're seeking observation in the.
दोनों एक साथ. ये 2 अलग हो जाएंगे. 2 अलग हो जाएंगे. List again.
Item of 16. Dilip Kumar Singh.
My lord, by Annexure 2, the petitioner has not only been debarred from the examination in which it is alleged that he has been found using unfair means, but another examination of the year 2023, and only they are allowed to appear in the 2024 examination. My lord, the reporting officer has given a report that he was found with a sheet of papers. He and there are other petitioners also, other candidates also by Annexure 2. And on that basis, they have taken a decision that he will be debarred from not only in the examination in which he was found using unfair means, but in the next examination also. My Lord, the admitted fact is that he was not given show cause before taking decision, my Lord.
Yes.
My Lord, on the last occasion I have placed before Your Lordship a judgment of 2016 of medical examination, interest examination, in which it was decided that in the case of mass copying, the rule of audio.
They had drawn a distinction between mass copying and
individual mass copying and the copying alleged using unfair single student or
in some case of unfair means.
Some students. Where large number of students found to be using unfair means or mass copying, then the examination itself will be cancelled. On the last one has been pleased.
The examination may be cancelled or whatever action.
Yes.
But principle of audi alter partem would not apply.
Would not apply. And this is the consistent decision of the Honorable Supreme Court right from 1970 till 2016. In that,
what kind of audi alter partem is required to be given? That is the question here.
Yes.
They say that since you had yourself admitted and before the concerned magistrate, and you have been already fined, you have been held guilty for the for having done cheating during examination. So for that purpose, now there is no purpose of giving you a show cause notice.
No, my Lord, in this it was under compulsion because he was in custody. A student of young age.
This is not a consideration for the court.
No, my Lord, I am saying
a
civil consequence is there. The criminal consequence, civil consequence, both are in a different yardstick altogether. Here I am going not only suffering the same examination, but the next examination. For the next examination also. Therefore, I am required to be given show cause.
All right.
The quantum of punishment, I can show.
Yes.
I can.
Yes, please address what are the judgments which you want to show.
No, my Lord, the first judgment of 1970. Again, it was a case of mass copying. Therefore, the Honorable Supreme Court, that is of Bihar School Examination Board versus Subhash Chandra Sinha and others. It is 1970, 1 SCC 348, 648, 1 SCC. And the parallel, I am just having a web copy also, my Lord.
Yes.
State of Punjab.
1970. Bihar School Examination Board versus Subhash Chandra. I am just placing the web copy, my Lord.
Yes. Which para are you referring to?
My Lord, I don't have that book, my Lord, but I have
a net copy, no?
A web copy I have got.
The web copy of SCC?
It is downloaded from Kanun website, my Lord.
All right. So which para? Please read that para. We will search it out.
It was also a case of mass copying. This is not a case of any particular individual who is being charged with adoption of unfair means, but of the conduct of all the examinees, or at least a vast majority of them, at a particular center.
I had asked you to go through earlier judgment on the last occasion. I remember clearly.
Yes, my Lord.
And you have not yet brought it. It has been cited in this case.
It has been cited in this.
So you should have brought that judgment. There are three students.
That judgment is also
1962.
62.
Ghanshyam Das Gupta's case.
This is also cited here.
But that was the case because there were three students there who were cheating.
Yes,
how the process is required to be done, that what the Supreme Court has laid down.
Yes,
आप आज भी नहीं लाए, आप mass copying वाले cases judgments लेकर आए.
In this case also it has been stated.
That is the assistance which we receive. I am sorry. I adjourned the matter, I remember very clearly.
I was under the impression that your lordship
On the last
wanted
occasion also, you had shown only these mass copying cases.
mass.
Yeah, thereafter I requested you to please bring individual matters relating to individual cases. The Supreme Court distinguished Ghanshyam Das Gupta's case in this case.
Yes, my lord. Ghanshyam, that is 1962 supply 3 SCR 36, my lord. It can be seen.
Then there is another judgment which he has cited, 64, Ranchi University's case. All those judgments discuss how an individual copying case would be examined by the authorities. And of late also there are people.
In 90s.
आप लाए हो? आप ही नहीं लाए हो?
Lord, since I have no quarrel with the legal proposition, I was just trying to distinguish this case factually from the law laid down by the Honorable Supreme Court, as has fallen from a lordship, that the facts in the present are slightly different.
Show any law where what I have said is just a viewpoint.
Lord, I am just on the exception.
It is not the law.
Lord, the petitioners are.
If we have to lay down such a legal proposition, it has to be based on some factual, some precedential law or something which you can bring as judgments or something.
Lord, I am on the exception.
Merely because a person has been convicted in a criminal case, can the principles of natural justice be avoided in your departmental proceedings? Like this is a departmental proceeding.
Lord, sir, I was just going through certain judgments, my Lord, sir. I could not.
Going through, then please show those. Please show those judgments to us.
I could not find exactly, my Lord, sir, in which such kind of facts has been dealt by either this court or Honorable Supreme Court, where, my Lord, the student has been.
All right. Any judgments which you have brought.
Lord,
that is the assistance which is required. You don't.
Then I will place, my Lord's judgments in which, my Lord's the Honorable.
पटना हाई कोर्ट से बहुत अच्छे जजमेंट जाते थे, हम लोग साइड वहाँ भी करते थे, पर लेकिन अभी तो आजकल आप लोग असिस्ट ही नहीं करते, तो करें क्या?
But the Honorable Court has given certain exceptions.
अभी खुद ही निकालते रहे, खुद ही बनाए.
Then I will come with the exceptions, my Lord, sir. I will just rely on the exceptions which has been just drawn by the Honorable.
The concept of judge advocate is there in New York, in USA, not here. Where they have a concept of judge advocate.
To save time, Monday, my lord, I will be assisting.
As and when you want. It is now a leisurely litigation for you both, it appears.
Monday, yeah.
Monday we have old matters. We gave us Thursday only.
Item 17. Case of a student, therefore I am.
What can we do?
Monday, if your lordship subject to your lordship.
Court is not going to be.
Because the next examination, special examination, is going to be held in 2023. They are going to hold a special examination in this year also.
Yes.
Apart from the annual examination. Therefore, if your lordships can.
Yes, we are keeping it next Thursday.
Item 17, Mr. Yashraj Vardhan.
Your Lordship, in this case, counter affidavit has been filed, Your Lordship.
We have received counter affidavit.
Learned counsel for the board states that a counter affidavit has been filed. Registry is directed to put the same on record. Reply to the counter affidavit, if any, may be filed within 2 weeks. List after 3 weeks.
Item 18, Mr. Jayavardhan Narayan.
May it please the Lordship. My Lord, on the last occasion, my Lord had been pleased to direct the respondent to file counter affidavit, my Lord.
Yes. Yes.
I am for the state, my Lordship. The Bihar School Examination Board is the main contesting party. My Lord, this is in regard to correction in the result sheet, my Lord, wherein.
Who appears for Bihar School Examination Board? Mr. Gyan Shankar.
counter. In this case, I need some time to file my reply.
The case where you have
Yes,
he falls in EBC category, you have treated him in BC category.
That's true. In one of the matters, Malords was pleased to decide in CWJC number 17,495/2021 on 21st/4/2022. Pursuant to this Malords directions, Malords, we have come out with an general notification inviting applications from all the candidates where Malords some mistakes were there.
Can you dispose it off in terms of that order?
Malords, I apprehend that he has not applied in right of that.
Because of pendency, we will dispose it off. So what was the last date there?
Last date was, my lords, the last date was 1/10/2022. It was time was time was given from 12/9/2022 to 1/10/2022.
He filed the petition in December 22.
My lords.
Then how much time will they give? The one opportunity, of course, can be given.
My lord, for majesty of justice, my lord, because the entire result of will be, my lord, meaningless if my caste is not changed, my lord. Just a last opportunity may be provided to the petitioner.
To file a counsel, place it on counsel, hearing counsel for the board. Board's time, list after 2 weeks.
Item 19.
Manoj Kumar. May please, Lordship. I am appearing on behalf of respondent, Lordship. On the last occasion, we are pleased to direct for filing counter affidavit, Lordship. We have received instruction, Lordship, which is under the process of.
Wait 2 weeks time, same order. You appear for the board?
Yes, my lord, I am prepared.
Item 20, analogous case. Item 20, Mr. Prashant Sinha, and 20.1, Mr. Kundan Kumar Singh.
Your Lordship, in this case, Senior Counsel Mr. Vindhyachal Singh will argue.
We don't know.
My Lord, he is on.
With all due respect, I am not much acquainted to all the seniors here.
For few cases only, my Lord. Only for few cases.
Then why should the other senior wait? Either inform him that we will be taking a Passover or something, so that he may not have to wait in the court.
Okay, my Lord.
That's the minimum courtesy which is required. If suppose you know the other side also a senior counsel is appearing, then and if your senior is not able to come, this is the minimum courtesy which is required to be advanced.
My Lord,
We will be taken up at 2, but our court is only up for half a day. So we keep it when, Mr. Singh? When should we keep it now? He is not here and I take Passover matters only after lunch. Otherwise, the entire cause list goes haywire.
After 2:15, I have another.
No, we were also not sitting because I have company matters after. When do you propose? Tomorrow?
Tomorrow, Monday. Tomorrow, I have no problem.
Tomorrow? Yeah, list again. So we have it on Saturday. We are working this time on Saturday.
This Saturday is also working.
No,
Saturday is not. No, this one is not a black Saturday. 25th is a working Saturday, I think.
See, but I believe the Chief Justice says that you can, the judges can continue working on Saturdays also. The acting Chief Justice has issued instructions.
That, of course, is your Lordship's privilege.
But my privilege is not to work.
If you want to.
All right. We have a lot of cases reserved which we do on Saturday.
Both cases.
Notice. Tomorrow.
Item 21. Mr. Prince Kumar Mishra.
This is the same matter, your Lordships.
My lords, although in my case, my lord,
we'll hear you tomorrow. See,
I have no problem. If he wants to carry on, I have no problem.
See arguments of the same kind, and if there is a senior already arguing some matter, you can always, take the advantage without engaging him. Tomorrow.
Item 22. Kumar Singh.
Lord, the petitioner laws has filed this writ application, Lord, for direction upon the respondent laws to recognize, Lord, the grant the affiliation and recognize the Lord the Sidhu Medical College Hospital, Lord, that is situated, Lord, in the Lord the Dumka, my Lord, by which, Lord, the state of Lord the Jharkhand Lords have already, Lord, granted, Lord, the recognized the Lord the affiliation for the Lord the state college. But Lord, the National Lord Medical Commission laws have not granted the affiliation. Therefore, the petitioner Lord praying for direction upon the respondent Lord to immediately grant the Lord the affiliation and recognize of the state college Lord as the Sidhu Kano Medical College, my lords, and hospital. Now, Lord, in this case, Lord, the petitioner will be Lord the director lords of the state college. In the strength of the director of the state college, Lord, the petitioner has filed this application. The Lord, the short fact note of the cases, the medical college was Lord established for 300 to 400 bed, my lords, of the medical college and hospital, my lords. For Lord the infrastructure, Lord, and the Lord the for provide the Lord the facility, Lord, the best facility, particular for the Lord the general people, my lords. And then, my lords, the petitioner Lord has filed this writ application. Now, my lords have kindly say, Lord, my 2 points, Lord, that I have to raise, Lord, in the writ application, my lord. My first, Lord, Lord, for recognition and affiliation, Lord, through the Lord, the National Medical College, National Medical, my lord. And second, my lords, my prayer, Lord, in this case is the petitioner, the director, he was appointed by the Lord, the chairman, Lord, of the state, Lord, the college, and Lord, during the Lord, the pendency of the Lord, when Lord, the college was established, the Lord, the medical college was running, Lord, in the Lord, the best Lord situation, my lord, and the infrastructure and development work, my lord. In the meantime, my lord, the chairman, Lord, has collected the money from the market, Lord, about Lord 10 crores, my lords, that has been collection from the market. On the basis of the Lord, the for donation, Lord, the several persons have donated the amount. This petitioner, Lord, he was donated, Lord, the amount of rupees 55 lakh, 20,000, Lord, in the charitable, Lord, the Sidhu Medical College and Hospital, my lord. And thereafter, Lord, he was, Lord, recognized as, Lord, the director of the state college, my lords. But subsequently, Lord, the chairman of the state college tried to, Lord, the extortion money from the market, my lord, and take a total project, Lord, of 264 point something, my lord, the crore, my lord, that was the project of the state college, my lords. And out of whom, Lord, about 10 crores, Lord, that has been collected from the market. You जाते हैं market में और सबों से charitable के नाम पर वो amount collection करके, and the amount was also defalcated by the chairman, my lords.
Was?
The amount was, her amount was defalcated by the chairman, my lords, of the state college. And due to that reason, my lord, the national Lord, medical Lord have not granted the affiliation, Lord, of the state college. So, Lord, the petitioner will be, Lord, in the strength of the director of the state college, Lord, file this application and bring for direction for recognition of the Lord through the Lord National Medical, my lords.
You are a director of the college?
As a director of the state college, my lords.
Is it a company?
No.
Is it a company registered?
Lord, the managing, Lord,
Is it a company registered under the Companies Act that you are a director?
Under the trust, my lord.
Trust.
The medical college.
You are a member of the trust, or you are a director?
I am also a member of the trust, my lords. And being the Lord treated as the director of the state college, my lords.
Director means what capacity is a director? Because the concept of director in a medical college is not there.
Lord, the 5-man committee.
Either you are a head of.
Altogether, Lord, the 5-man committee, Lord, the government committee was constituted in the state, Lord, the college, my lords. Out of whom the petitioner, Lord, being the Lord,
You
the
are
director of the
one
state
of the
college.
members of the board of governors.
My lords.
So has it been recognized under the statute as a board of
My lord, the state government, Lord, Jharkhand has already recognized, my lord, the official minority. But, my lord, the kindly say, the national, my lord, National Medical Commission, Lord, have not granted, Lord, the affiliation.
So how is the medical college being started? It has not yet been started.
No, that has been started. That is,
how was it started?
Condition, my lords.
So was it recognized by a medical council?
My lord, initially, Lord, there was a provision for grant the affiliation and Lord recognition through the Lord state. Now, Lord, subsequently, Lord, through the Lord state government, my lord.
When was that?
My lord, the state government, Lord.
Simply state government recognizes and medical college.
No. Through the Lord, the National Medical Lords Commission.
That is what we want to know.
And for that reason, my lord, when the college was established, the work was completed. Now, my lords have kindly see the entire project work. My lords have kindly see page number 23. My lords.
Sir, please be clear on facts at least. I am very slow in
college was not fully loaded.
You showing the
entire infrastructure.
Showing this photograph will not do. What we are asking you, whether your medical college was established, recognized by Medical Council of India or commission.
And for that reason, my lords, that I have to file this application for grant the.
It has not never been. So you agree that it has never been granted?
My lords, at the time of filing of the writ application, that I have got information that the recognition was not granted by the National Medical.
Nor by earlier MCI.
Earlier MCI से था. बाद में हुजूर नेशनल मेडिकल कॉलेज है।
यही हम पूछ रहे हैं आपसे।
जी अर्लियर था, जी पहले था।
वो बताइए वो कहाँ है?
वो that I have not brought on the record.
From where? Because you say that it is a medical college which is already registered with the MCI.
Of course, my lord. That was registered, my lord. Under the MCI, my lord.
When? Which year?
In 2015, my lord.
So you started getting students?
2015, the recognition was granted by the MCI, my lords.
So you started getting students?
Ji, several students brought in the seat college, my lord. But during the pendency of the lord, when the work was started and the development infrastructure was under the guidelines of the National Medical Commission was not filled up by the college. So the एक साल के लिए हुजूर होता है, हर ईयर के लिए उसको ग्रांट करता है पहले। तो कुछ दिन के लिए किया, लेकिन बाद में जब
कुछ दिन का बताइए ना, कौन से कुछ दिन? आपने कहीं लिखा होगा ना कहीं? कुछ दिन कितने दिन कर लिया?
Actually, Lord, that Lord, the paper, Lord, that was not Lord, which means for that.
हम आपसे ये पूछना चाहते हैं कि आप एग्जैक्ट बात कब बोलेंगे? फैक्चुअल एस्पेक्ट तो सही बोलिए कोर्ट के अंदर, because you know, as a lawyer, you are supposed to give us correct facts. Till now, you are not giving us correct facts, and you might be saying we have still a doubt.
Lord, about the grant of recognition through the Lord MCI.
Your statement has created a doubt in my mind whether what you are saying is correct. So please let us know which year you were granted first recognition by MCI, which year you started your college. Starting of college doesn't mean starting of your building of the college, but when you started your students. Please let us know.
My lord, so far, Lord, the MCI, my lord, is concerned, my lord, the recognition is concerned, my lord, that.
Anywhere have you stated?
Lord, that I have taken, Lord, the consent, Lord, from the Lord, the instruction from my client, my lords, because that I have got no knowledge, Lord.
Then how do you say that it is recognized?
Those papers that I have not brought on the record, my lords.
It is not here, it is not there. So you have never received any recognition. There are no students in your college. Be at least honest to the court.
Student, not the college is established. College is not in any condition, my lord.
You have admitted students without.
Several students, my lord, they are not took the admission in the same college. The college was fully established, my lords.
All right. Show from your affidavit.
So you just go after 4 weeks. In the meantime.
No. We don't entertain colleges. We don't entertain petitions which are factually incorrect.
तो हुजूर उसको नेक्स्ट वीक रख दिया जाए, हुजूर हम मान लेते हैं।
And if there is a dispute only which you have brought relating to you and your chairman, if that is all, then go under the Trust Act. You don't have a public trust act here?
Chairman Lord.
There must be a public trust act.
Chairman Lord is Lord trying to create the nuisance in the state college.
All right. So if there is a dispute, get him off state. Get your new chairman, get a declaration done under the Public Trust Act.
The dispute is concerned, till this time, Lord, I am working, my lord. So there was no such dispute on this very point, my lord.
But you are working, you don't want him to work, no? He has embezzled the amount.
I am not working, but Lord, the chairman, Lord, he is trying to, Lord, create the nuisance, Lord, in
So what is the remedy?
In this case, to protect the petitioner for, Lord, function, the work, Lord, in the state college, Lord, and discharge his duty as a regular.
So what is the remedy available under the law? To come in writ petition?
No, read petition is being filed particular for recognition of the Lord through the National Lord, the Medical Commission, my lords. They did one file.
Why should we direct them when you are yourself having a dispute between you and?
There was no dispute. हमसे dispute उसमें ये नहीं है. Only the chairman who have collected the money from the market. So one of the Lord, the point that I have to raise in my petition, there was Lord the hug amount was defalcated by the chairman, my lords. Thus, about 10 crore, my lord, that has been Lord defalcated by the chairman, my lords. अब उसी के चलते डेवलपमेंट पूरा वर्क नहीं हो पा रहा है उसका कॉलेज का जो फैसिलिटी होना चाहिए वो नहीं हो पा रहा है वो सारा पैसा तो खा जा रहे हैं वही चेयरमैन है वही डिफॉल्टेशन कर ले रहे हैं दैट कैन बी मेड रीजन माय लॉर्ड्स and for that reason Lord the
Mr. Counsel, that remedy does not lie here.
Lords.
The remedy does not lie here. If any member of the trust is taking away the funds of the trust, the remedy lies elsewhere, and we are not here to advise you. Law is very settled where you can go.
Trust, Lord, the medical college has already been established, my lords. Is in a running condition. Several countries, Lord, they have put the admission.
Where do you say so?
हमने तो जो फाइल किया था सिर्फ रिकॉग्निशन के लिए कि हमको नहीं मिल पा रहा है इसके लिए हमने फाइल किया है
तो आपने रिकॉग्निशन के बगैर स्टूडेंट्स का एडमिट
नहीं रिकॉग्निशन हमने लिखा है कि रिकॉग्निशन स्टेट गवर्नमेंट से मिला हुआ है आपको हमने लिखा है स्टेट गवर्नमेंट से आपको रिकॉग्निशन मिला है झारखंड स्टेट से
हाँ बताइए ना क्या आपको मिल गया आपने स्टूडेंट्स एडमिट कर लिए
Para 5 that I have stated, my lord, that when the head office was established at Asiana Nagar Gillespie Division Road, Patna, Bihar, and the website of Sidhu Kano Medical College and Hospital, who is duly recognized by the state government of Jharkhand on PPP mode, public-private partnership, by which the state college was registered through the state government of Jharkhand, and when the foundation of the college was started for development of the infrastructure of 20 bigha of land, by which the first floor of the building was completed. So far, the prospectus of the said college was also uploaded on the website. Sidhu Kano.
नर्सिंग डिग्री में आपने एडमिशन करे
मेडिकल कॉलेज का भी हो गया पहले
आप
नर्सिंग का भी
पढ़िए
हाँ नर्सिंग का भी है उसी में और उसमें हुजूर मेडिकल कॉलेज का भी है दोनों है हुजूर पैराग्राफ 8 देख लिया जाए हुजूर हमारा
ऑलराइट व्हाट विल
पेज नंबर 2
डायरेक्ट द स्टेट विजिलेंस अथॉरिटी टू कंडक्ट एन इन्वेस्टिगेशन इन योर कॉलेज and if you find that your facts which you
my lord
are what you are saying I am recording those statements.
Your Lordship, my statement may kindly be recorded.
That sounds for the petitioner state.
Lords, one summation, Lords. As per my understanding, Lords, this para 7, Lords, says these are the degrees for which, Lord, the case the college is functioning and established. We are not dealing with these, Lords.
That we know.
We are not dealing with these.
You are not having students of medical college.
Para 8, my lord. Para 8, my lord, that I have a specific the amendment which has been made, my lord, that a project for setup of medical college including 300 bed capacity hospitals, my lord, hospital up to 400 beds, my lord, and the project of the Sidhu Medical College total a cost of rupees 264.60 crores, and the governing body of the medical college as per the cost of the entire infrastructure was completed.
On second thought, we will not entertain this petition at all. Why should we unnecessarily go into this?
अगर मुझे रोज जांच हो जाएगा ना सारा हो जाएगा आ जाएगा उनका
be successful in getting what you want from this court.
I am not only
which we don't want to enter into.
My submission,
the petitioner.
My submission.
Anything else which you want to say?
Lord, my submission, Lord, in this case, if Lord through the Lord the business department, the inquiry has been made, everything it will be clear, my lord.
No, we will not go into fish.
And if my lord,
sorry,
And so far, my lord, my submission in this case is, so far the lord, through the lord, the MCI lord is concerned, my lord, the record lord that lord, at present lord, which is not available with me, but lord, after 1 week, lord, in the next week, that I have to lord.
We will see what is there in this petition. That's all. No, we don't want.
I feel it that it was necessary for
we are
that.
not satisfied.
That I have not annexed, my lord, and
We are not satisfied. We are not satisfied. Sorry. Nikki, the petitioner by way of this writ petition prays as under. The first prayer made by the petitioner is in relation to seeking a direction for grant of recognition of medical qualifications of the medical college. In terms of the Medical Council of India Act, National Medical Council Act, है ना? वो लीजिए हमसे. The National Medical Commission Act 2019, the central government, on basis of the recommendations of the petition, is empowered to establish and recognize a medical college, established for Kalpani, to recognize a medical college, whereafter the medical college is empowered to take admissions of students. Since the petition does not mention about the steps which it has taken and the stage up to which the process is being continued with the under the National Medical Commission Act, no directions can be issued to the respondents to recognize the qualifications. The prayer is fully misconceived and is accordingly rejected. As regards the prayer 1 and 2 are rejected. As regards prayer number 3 is concerned, it appears to be a dispute between the members of the trust. The allegations mentioned are in the nature of a complaint which cannot be examined on factual aspects before this court. The writ petition is wholly misconceived, is accordingly dismissed. Dismissed as wholly frivolous. A cost of rupees 20,000 is imposed on the petitioner to be deposited with the legal service authority.
Item 23.
We will not allow this kind of litigation.
23, Mr. Vinay. Item 23, Mr. Vinay Kumar.
Yes,
Dean of India.
Yes.
हम रिटायर किए हुए हमको 2 साल हो गया है लॉर्ड, और हमारा रिटायरमेंट बेनिफिट वगैरह सब पेंडिंग है, और हमारे अगेंस्ट में रिकवरी का ऑर्डर हुआ है.
कब हुआ है?
2,75,000.
When the order has been passed?
Order passed
after retirement or before retirement?
After retirement.
All right. Issue note, reply be filed. In the meanwhile, no recovery shall be effected from the petitioner who has already obtained superannuation.
Private respondent is also in this writ application.
Issue notice to respondent by ordinary as well as registered post, returnable 4 weeks, 5 weeks.
Item 24.
वकीलों के एक्सीडेंट कब से होने लग गए? यहाँ पे तो ट्रैफिक इतना भी खराब नहीं है कि
अपना बाथरूम में
Item 24.
Take care.
May your lordship be pleased, my lord. There was a remark, my lord, which was not factually correct, so I'll just clarify that. यहाँ पर ट्रैफिक बहुत खराब है हुजूर, उनका कम ही टूटा है. It's really bad. Yeah, I don't know if my lord has had.
I just made a remark so that you may be aware of what is there actually, and you should all take some steps.
It's very bad, my lord. It's very bad.
Some steps should be taken. You have three bar associations, and I don't find them doing anything for the citizens of this place or for the citizens of Bihar. Bar associations are meant for many other things apart from taking care of your lawyers alone.
The bar was quite proactive, my lord, and there are reported judgments. There had been one.
That's what I know about, and that is what I was told about.
It was Corona, my lord, that had affected a few things and a few more things that we cannot quite openly talk about. However, my lord, the bar here has been very.
All right, we will discuss it somewhere else.
There are a few reported judgments also.
We will discuss it somewhere else.
My lord, may your lordship be pleased. This writ application, my lord, is directed against the order dated 16/11/2022, my lord, passed by the district education officer, by which the services of the petitioners were terminated without, my lord, firstly following the provisions contained under the Bihar CCA rules, as neither a copy of the inquiry report was handed over to them prior to the passing of the order, my lord, nor had they been afforded the opportunities to participate in the inquiry in terms of the provisions contained under Rule 17 of Bihar CCA rules. Rules 17 and 18 have been flagrantly violated. And additionally, my lord, it is also in the teeth of a direction of the Honorable Supreme Court, my lord, as is contained in Annexure 10 to the writ application, by which, my lord, it had been clearly and in no uncertain terms directed by the Honorable Supreme Court that such persons who have been appointed against the vacancies out of 34,540 vacancies of teachers, my lord, they were not to be disturbed in any manner. The present petitioners, on the basis of process of selection, as was conducted pursuant to the orders of the Honorable Supreme Court, my lord, had been appointed way back in the year 2012 itself. And despite that, my lord, while referring to a matter which had no connection with the present case,
so their services were terminated.
Their services have been terminated.
So they do not fall with that the category. There is a division bench judgment that they don't come before. They cannot go to the district appellate authority.
They can. These are assistant teachers, my lord.
So they cannot go.
They cannot.
That is the what division bench says.
Recently, my lord. Yes, it is only with respect to Niyojit Shikshaks, the honorable.
This is what they say. And the argument was that there is another forum of appeal. So go there.
There is no forum of appeal.
That is the argument which was raised. Go there under the act.
My lord has already issued notices in similar matters.
No, you go there under that. Where is that judgment of division bench?
Appeal.
There is that is what
but
was
argued. My lord,
this is what, so against termination also.
They are protected by 311(2) of the Constitution, my lord. These are government employees. So the assistant teachers, my lord, are
file an appeal if that can be done.
My lord,
that is an adjudicating authority.
My lord has already issued notices in same matters arising out of same orders.
So that we will correct now after this division bench judgment.
Division bench, my lord, I would respectfully submit does not really affect us. What was argued there, my lord, we would if it is the forum was before a different authority. In this case, my lord, it cannot. There is no provision for appeal, so to say, my lord, before any forum.
बड़ा जजमेंट आपने
अभी तो नहीं देखा हम लोगों ने
पढ़ लो फिर आना.
But these matters, my lord, has already
said that Suresh Ram was governed is with regard to 2015 rules, which stood already repealed in 2020.
They will be filing a review, my lord. But so far as this matter is concerned, my lord, we will.
And then it says that the Bihar nationalized promotion rules 2018 transfer disciplinary action rules are there.
We are not
under Article 309.
We are under Bihar CCA rules, my lord.
No, it says Bihar nationalized these teachers would be governed by Bihar Nationalized Primary School Teachers Transfer Disciplinary Action and Promotion Rules 2018.
That is a different set of teachers, my lord. That is nationalized school teachers, my lord. There are several categories of schools that are there.
That
my
is
lord.
there, that we know about disciplinary regulation.
But this would not affect us because the provision that has been
So
invoked
if it is under the rules of 2005.
No, we are, my lord, yes, deeply obliged. 2005.
The rules of 2005.
My lord.
Then there is appellate forum there also.
But that appellate forum, my lord, if it is the teachers who have been appointed by the orders, my lord would see, annexure 19 may kindly be seen, my lord. And this is against, in the teeth of the orders of the Honorable
The order has
Supreme
been
Court.
passed under what rule?
Under CCA rules, my lord.
Under which rule? 17 or is it under rule 19 or what? Where is the impugned order?
The impugned order is annexure 19, my lord. I'm sorry, page 103. I'm sorry. That should be the last of the pleadings, my lord. Last page, right before the wakalatnama.
ये तो simplicity termination का
annexure
not
4
an order under rule 2.
They do not mention that. However, annexure 14 would show, my lord, that it is
बाकी
under.
कार्रवाई उन्होंने खत्म कर दी पूर्ण करते हुए that has been dropped and they have said that because it is not all the certificates which have been issued by this particular college, the services stand terminated.
My lord, yes. This is what they state.
Termination order does not come within the ambit of removal or dismissal.
The order that
termination would be different from removal and dismissal.
What they say, my lord, is that seva समाप्त की जाती है. Samapti will be, my lord, terminated service, my lord. So this is termination order, and it has been initiated by the annexure 14 and 15. That is under CCA rules. If I may be permitted to place that, my lord. Annexure 15 at page 90, my lord would see. Sorry, my lord would
Issue
find.
notice.
Yeah.
File your reply.
That, my lord, people will be filing against.
I don't know.
हम number इसका लिख दे देते हैं. My lord, if a date may be fixed because they had been working since.
There is another case now which is notices have been issued.
This is 19/12/2022. My lord had directed to be listed on.
Tag along with CWJC after 4 weeks.
Deeply obliged.
Item number 25.
Pursuant to my lord's last order dated, my lords, 3/2/2023, my lords.
Yes.
I have been notified as the head of the department, my lord, on 6th of February, my lords.
Pursuant to your lordship, last order, the registrar was directed to be physically present in the court, your lordship. Though we have filed an IA stating that there was a meeting and he couldn't come, but now meeting has been adjourned and the registrar is here, your lordship. We have tried to explain it in the IA application, your lordship. There is no regular registrar in the University of Magadh University right now, and the registrar of Jayaprakash University Chhapra is.
No, you do not press it.
My lord, since I have been.
Yes, where is that order?
My lord, they have filed.
Registrar is present and it is informed that
They have filed an
on account of there not being a regular posting, delay has occurred in issuing of orders. However, an order has now been issued on 6th February 23. Allowing the petitioner to continue as head of the PG Department of Psychology with immediate effect. The order dated 6 February 23 is directed to be taken on record.
I will be giving a photocopy, my lords.
We have filed it in an IA application. It is on.
Since IA is not on record, I will be filed.
Taken on record in terms of the IA filed by the respondent registrar. The registrar is directed to place the IA in the file. Keeping in view the orders, the learned counsel for the petitioner does not further press this petition. The same is accordingly disposed of.
My private respondent. I have filed wakalatnama.
Private respondent, Mr. Sharma appears for the minister.
Item 26, fresh cases.
My lord, petitioner number 1 and 2 was the untrained panchayat teacher, and
In this case,
petitioner
affidavit has been filed, my lord, court copy may I permitted to file this.
both petitioners successfully completed the training course, but on the last fourth semester he was failed, my lord.
You filed your counter?
Yes.
Learned Council for the state has filed its counter. Registry is directed to place the same on record. Reply to the counter if any may be filed.
Online file has
अभी ठीक है आप वहाँ पेश करें. Just after reading.
Item 27. Mr. Jitendra Prasad Singh.
In this case, petitioner was working on the post of assistant. He has been terminated by the order of director on the report submitted by the committee which was constituted by the university. Milord, the allegation against the petitioner was that Milord, he had issued Milord, the I-card to the students without Milord, obtaining permission from the Milord, the director. Now Milord, the so-called notice Milord was issued, which was properly replied by the Milord petitioner, stating therein that the Milord, the proper permission was obtained by from the director, but without consulting the Milord, the so-called, and without giving an opportunity of hearing, the petitioner has been terminated.
File an appeal.
Contractual.
You have an appeal provision before the chancellor.
Yes, before the vice chancellor, Milord, I have filed a representation.
So you have filed an appeal before the chancellor.
Vice chancellor, honorable vice chancellor.
Vice chancellor had already passed an order. No, who has passed the order?
Director, Milord. Director of the Milord, the institute.
Petitioner is contractually appointed.
So let him file an appeal.
Yes, yes,
my lord.
Appeal is learned counsel for the petitioner submits that he is the petitioner has filed an appeal against his removal before the vice chancellor.
Yes.
Which is pending.
Yes.
Taking into consideration contents of the case, contents of the writ petition. This court deems it appropriate to direct the vice chancellor to pass a speaking order after giving an opportunity of hearing to the petitioner within period of 3 months.
If Milord, the one thing, I have filed Milord, I will next. If the Milord, the appeal is not filed, then I will file.
आपने स्टेटमेंट दिया, हमने आपका स्टेटमेंट रिकॉर्ड कर लिया.
Yes.
अगर आप कहते हो कि आपने अपील पेश कर दी
है,
प्रेजेंटेशन दिए हैं,
in the way of representation,
appeal in the nature of representation कर.
हाँ.
Dispose of.
Item 28, Mr. Binod Kumar.
This writ application is for passing of letter dated 5/4/21, my lord, issued by the district program officer, and further for holding the validity of the degree of the Deoghar Vidyapith, my lord. So, my lord, the annexure 4 is the impugned order at page 25, my lord. So my annexure 4, my lord, at page 25. This is the, ये कहते हैं ऊपर से ये पिकुलियर ऑर्डर है हुजूर, हमारा स्टैंड एक्सेप्ट भी कर रहे हैं और फिर कह रहे हैं चूंकि आज तक नहीं किसी को दिया गया है इसलिए आपको भी नहीं दिया जाएगा. दो ही माय लॉर्ड, मे आई परमिटेड टू रीड माय लॉर्ड दी पारा 4 ऑफ दी. अंकनीय है कि सरकार के अवर सचिव प्रशासन विभाग द्वारा 8/4/26 द्वारा जारी अधिसूचना में हिंदी विद्या के आधार पर की गई
How can you pass such an order saying that it stands recognized before 8/4/2016, the qualification?
Your Lordship,
He passed this exam qualification when?
सब हम 12 के पहले किए हैं हुजूर. I have a specific statement in my writ petition as well as in my rejoinder. और नेवर ये जो एक पारा 6/7 जो काउंटर का है कि हमारा कंसीडर किया गया, ये नेवर कंसीडर किया गया, खाली इनवाइट किए थे हमारा.
क्या किया आपको बता दिया, क्या किया या नहीं दिया बेनिफिट?
नहीं मिला हुजूर, आज तक नहीं मिला, जबकि ग्रेडेशन लिस्ट बना हुआ है हमारा, हम लोग का नाम है सबका पिटिशनर का, बट इसके कारण लास्ट पर देखा जाएगा
ठीक
हुजूर
है, आप
इनके
जवाब दे दिया आपने?
जवाब दे दिए।
Yes, Your Lordship, Annexure A of counter affidavit
ये
filed by respondent number 5, therein the second last paragraph and last paragraph, it's clearly mentioned. This also makes clear that no further appointments, promotion can be given on the basis of certificates granted by Hindi Vidyapeeth, Deoghar, treating it equivalent to matric IA and BA. And the last paragraph, अतः सम्यक विचारोपरांत स्पष्ट किया जाता है कि हिंदी विद्यापीठ देवघर द्वारा दिनांक 7/5/2012 से पूर्व प्रदत्त उपाधियों के आधार पर दिनांक 7/5/2012 के अधिसूचना ज्ञापांक 5267 दिनांक 8/4/2016 निर्गत होने के बीच की गई नियुक्ति प्रोन्नति उक्त अधिसूचना के अप्रभावित रहेगी।
यही तो हमारा स्टैंड है हुजूर, यही तो हम कहें। परंतु दिनांक 8/4/16 के पश्चात उक्त उपाधियों के आधार पर कोई नियुक्ति प्रोन्नति नहीं की जाएगी। तो हम तो 2012 के पास हैं। आई हैव ए स्पेसिफिक स्टेटमेंट दैट हैज नॉट बीन डिनाइड माय लॉर्ड। जरा सा लास्ट में एक अनेक्चर हुजूर को हम और दिखाना चाहते हैं। रिट पिटीशन का अनेक्चर 8 है हुजूर।
काउंसिल, if you are to be promoted, is it going to be from an earlier year?
That's what he's asking for.
No, my lord, I have metric 10.
Suppose you are to be promoted, if we direct that you should be promoted, then is it for a particular year that you will be promoted, or you will be promoted from today?
No, my lord, juniors have been promoted from 2018.
2018.
My lord.
Not prior to 2016. No one has been promoted prior to 2016.
वो they are not belongs to Vidyapeeth degree.
I am asking.
They are general degree.
We are asking you, any junior person promoted, junior person junior to you has been promoted prior to 8/4/2016.
My lord, kindly
please answer.
Annexure 8. Yes, my lord. The director is issuing letter. कहते हैं कि माननीय उच्च न्यायालय के, और उसके बाद यहाँ लिखते हैं कि अंकित करना है कि CWJC इतना में ये फुल कोर्ट का जजमेंट था हुजूर, जिसके अगेंस्ट में ये अपील में आज तक गए नहीं है, न कोई स्टे ऑर्डर है इनका।
आप बात को समझ गए हैं, पर लेकिन अब आप जवाब नहीं दे रहे। No one was promoted prior to 8/4/2016 who is junior to you. So your promotion will not relate back prior to 8/4/2016. After 8/4/2016, they have taken a decision not to give any promotion or appointment on the basis of that degree.
But they are clearly, even the secretary of the department has accepted this standard कि दिया जा सकता है, यहाँ तक 16 तक वैलिड है इनका। हम 12 में पास किए हैं, that has been admitted by the respondent itself. तो हमारा हुजूर तो वो
तो आप इसको चैलेंज करते 24/8/2017 का जो ऑर्डर है नोटिफिकेशन।
तो नोटिफिकेशन तो इसमें हमारे फेवर का है हुजूर। ये तो
नोटिफिकेशन ये कह रहा है,
ये तो हमारे
8/4/2016 के पश्चात उक्त उपाधियों के आधार पर कोई नियुक्ति प्रोन्नति नहीं की जा सकेगी। उक्त उपाधि जो आपने ले ली है प्रायर टू 2016, उसके बेसिस पे कोई नियुक्ति या प्रोन्नति नहीं की जाएगी।
लेकिन
आप या तो इसको चैलेंज करते हैं।
हुजूर, may I permitted to place this again this paragraph of the।
आप इस सेंटेंस से क्या समझे?
वो तो कहते हैं कि
ये सेंटेंस फिर से पढ़ लीजिए और बताइए कि क्या समझते हैं आप। शायद हम गलत समझ रहे हो।
नहीं लॉर्ड, आई एम सेइंग दैट हम हुजूर, हम सिर्फ इतना ही हमारा सबमिशन है कि
ये जो डायरेक्शन है, आपने इसको चैलेंज नहीं किया है कहीं। आप चैलेंज करें तो हम एग्जामिन करें कि भाई ये गलत है, ये सही है। आपका आर्ग्यूमेंट जो है कि साहब हमने तो उस समय 2012 में कर ली थी और वो रिकॉग्नाइज क्वालिफिकेशन है, उसको इन्होंने नहीं माना। होगी रिकॉग्नाइज, पर हम नहीं देंगे नियुक्ति और अपॉइंटमेंट, ये कह रहे हैं।
और उसके ऊपर में कह रहे हैं कि 16 तक
ये तो गलत तो है, अगर है गलत है ये सही है, इसको आपने चैलेंज नहीं किया तो हम क्यों एग्जामिन करेंगे इसको?
हम उसी आधार पर तो आए हैं यहाँ।
आधार अलग बात है, आपने चैलेंज नहीं किया है नोटिफिकेशन।
ये चैलेंज किए हैं इसको सुप्रीम कोर्ट में, लेकिन आज तक इनको स्टे नहीं मिला है। फुल कोर्ट का जजमेंट भी हुजूर हम लगाए हुए हैं एनेक्सचर उसका, जरा सा काइंडली उसको हम पूरा लगाए हुए हैं उसमें हुजूर। उसी के आधार पर एनेक्सचर 8 दिखाना चाहते हैं कि इन्होंने दे दिया जो हुजूर कहा जा रहा है। डायरेक्टर का लेटर है एनेक्सचर 8, एनेक्सचर 7 at page 31 is the order of this honorable court, my lord. This is full court, फुल बेंच जजमेंट है जो इसको इन्होंने अपने काउंटर में कहा है और लेटर में भी कहा है कि अपील से प्रभावित रहेगा जो प्रमोशन दिया जाएगा इनको। ना ये आज तक स्टे ऑर्डर लाए हैं, कहीं इनके काउंटर एफिडेविट में एक लाइन भी नहीं है कि उस ऑर्डर के खिलाफ इन्होंने स्टे फाइल किया भी हो उसमें। और उसी आधार पर दिया गया है दूसरे डिस्ट्रिक्ट में हुजूर। ये बेगूसराय की, औरंगाबाद, किशनगंज, अररिया एनेक्सचर 8 में हम लगाए हुए हैं। दिस लेटर हैज बीन इशूड बाय द डायरेक्टर ऑफ प्राइमरी एजुकेशन। कहते हैं कि वे इसी फुल कोर्ट के जजमेंट के ऑर्डर के आधार पर कहते हैं कि राज रंजन बनाम में संलग्न वादों के बिना कितना को पारित न्यायाधीश के आलोक में विषयांकित वाद संलग्न वादों के वादियों को जिन्होंने हिंदी विद्यापीठ देवघर से साहित्य अलंकार की योग्यता हासिल किया है, प्रोन्नति देने पर सहमति प्रदान की जाती है। उक्त विषयांकित वाद संलग्नों के वादियों को दी जाने वाली माय लॉर्ड पेज 64 एनेक्सचर 8 माय लॉर्ड, एनेक्सचर 8 रीट एप्लीकेशन में एनेक्सचर 8। ये कई सेवरल डिस्ट्रिक्ट्स में दिया गया है हुजूर। इसमें कहते हैं कि इसी जजमेंट के आधार पर दिया गया है, लेकिन ये अपील से प्रभावित रहेगा इनका प्रमोशन। I don't know whether that appeal has been filed there or not, any stay order is there or not, that is not on record in the counter affidavit filed by the This letter has been issued by the Director Primary Education, my lord। कहते हैं कि दी जाने वाली प्रोन्नति माननीय उच्च न्यायालय से आदेश से प्रभावित रहेगी। उसके बाद कहते हैं जो योग्यता हासिल किया है प्रोन्नति देने पर सहमति प्रदान की जाती है। दिस लेटर इज इन ईयर 19।
This order has already been examined by the division bench. Come to page 52. This notification has already been clarified by the division bench. It was challenged.
Perhaps full bench judgment has
Your Lordship, it's also
See, come to this page 52. It has been quoted in the order. परंतु दिनांक 8/4/2016 के पश्चात उसको भरने के आधार पर कोई नियुक्ति प्रवृत्ति नहीं की जा सकेगी। And after considering that, they said that it is ultra vires. You cannot do this way. He may not have challenged it, but then it has already been examined by the division bench. Anything else you have to say? Nikki, the petitioner by way of this petition has prayed again. The learned counsel for the petitioner submits that the question regarding the qualifications obtained from Hindi Vidyapeeth Devghar
Your Lordship.
was a subject matter of
Yes, Your Lordship, paragraph number 11, wherein
paragraph 11 of what?
Counter affidavit respondent number 5. In the terms of Bihar Elementary Teachers Promotion Rule 2011, graduate means a degree at graduate level granted by the recognized university, and this university was not a recognized institution.
That issue stands already concluded. Was a subject matter of protracted litigation before this court. The writ petition were filed on the ground that the qualification of Sahitya Alankar being awarded by the Hindi Vidyapit Devdhar was recognized qualification till the state government issued a notification on 8/4/2016 holding the qualification to be de-recognized for the purpose of appointment or promotion. A notification was also issued on 24/8/2017, whereby it was directed that while the qualification has been de-recognized with effect from 8/4/2016, but after 8/4/2016, no person would be granted appointment or promotion on the basis of qualifications already obtained even prior to 8/4/2016. Para. The petitioner had acquired the qualification in 2012, but was not granted promotion. He therefore preferred a writ petition before this court, and directions were issued. CWJC 4328/2019 to the respondents to examine the case of the petitioner and dispose it off by a reasoned order. Accordingly, an order was passed on 5th April 21 rejecting his claim holding that after 8/4/2016, no promotion can be awarded on the basis of the qualification acquired even before 8/4/2016 from Hindi Vidyapit Devdhar. Stop. Almost identical issue came up before our division bench in letters patent appeal. And CWJC 5129/2009 decided together on 18 July 2019, wherein after noticing the order dated 24/8/2017, bracket में कर देना supra, and also the order dated 8/4/2016 the court held the qualifications acquired prior to 8/4/2016 would be recognized qualification equivalent to a graduate, and the persons would be considered for promotion on the basis of the said qualification. And treated to be eligible for consideration of promotion. Learned para. It would be opposite to quote the directions issued as under para 17 quote कर दीजिएगा पेज 31 पे स्टार्ट होता है और up to page 32 डेट से मार्क कर दिया पेज 61-62 है petition. Learned counsel for the petitioner has also relied on the order passed by the Education Department dated 16/12/2019, whereby similarly placed persons were awarded promotion. Para. Having noticed aforesaid aspects, this court finds that a similar relief deserves to be granted to the petitioner. Petitioners too, as they have acquired Sahitya Alankar degree prior to cut-off date, that is 7/5/2012, and the same is a recognized qualification to be treated as equivalent to graduate, since the requirement of promotion is that a candidate must be graduate, the petitioners too would be entitled to be considered for promotion even after 2016, as their qualification would be recognized for all purposes.
One thing, my lord.
If the exercise has not been conducted till date, the respondents are directed to conduct an exercise and grant promotion to the petitioners from the date juniors have been so promoted. They would be entitled to all consequential benefits.
उसमें स्पेसिफिकम 6 से 7 पारा में एडिट कर लिखे हो, जो कि एक्सरसाइज 2013 में ही स्टार्ट हो गया था, हम लोगों से मांगा गया था।
और कुछ रह गया क्या?
वो 13 से कर दिया तो
स्टेटमेंट ठीक लिखाना आता नहीं, आप लिखे
नहीं माय लॉर्ड,
कुछ रह जाता है।
सब जो पूछा गया था इफेक्टिव डेट का, इसलिए हम कह रहे हैं बस।
I put 29, Mr. Sachin Kumar.
Page 18. Order of removal from service of sweeper post, holding that the Agarwal Commission has held that the petitioner was not entitled to regularization.
Which post?
Page 18. in compliance of Governor's Secretariat letter number so and so and Higher Education Department government letter so and so and subsequent letters so and so, the Vice Chancellor has been pleased to remove the following teachers and non-teaching employees of the university from their services with immediate effect as their cases are not eligible, found fit for regularization by the Agarwal Commission.
Found eligible for regularization.
My Lord, can I see that I was appointed on compassionate basis after death of my mother in harness. That is, appointment letter is annexure 1 at page 14.
You are going what percent? Srimati?
Lord, I am on next page in the bottom serial number 35.
पुनराम आपने तो और भी कर रखे हैं विजय कुमार सिंह और
he is another person. I am Munna Ram.
They have also filed writ petition here.
Vijay Kumar Singh.
इनका भी writ petition फाइल हुआ है क्या? विजय कुमार सिंह का और ये क्लास 4 एम्प्लॉइज.
My letter of appointment is annexure 1 at page 14. That I was appointed on compassionate ground after death of my mother in harness.
Have they filed their reply?
No, my lord.
You are working?
No, I have removed.
When were you removed? To that time? Long back?
Long back, my lord. It is 2008.
Reply me file.
Obliged.
Item 13, Mr. Uday Shankar Singh.
May I proceed? This is a question for quashing the order passed by the State Plate of Bangalore by order dated 19/5/2022. Appeal number 377 and 19 law. Lord, kindly see, my lord, annexure 5, my lord, page 25, my lord. Order of the District Capital Authority, my lord. May I permitted to read? My lord, पैरा 4 में नियोजन समिति ने अनारक्षित श्रेणी में 4 रिक्तियों के विरुद्ध अभ्यर्थियों का चयन किया. बाद में अनारक्षित श्रेणी के संजीव कुमार Hello.
Which page are you reading?
Annexure 5. Page 25. जिला अपीलीय प्राधिकार का ऑर्डर. सेम एंड सिमिलर, सेम पंचायत का सेम एक ऑर्डर हुआ है.
अब ये केसेस है ना जिसमें आफ्टर डिले आफ्टर 6 years appeal has been filed. We have already stayed this side. Yes?
Same terms है, same terms.
Issue notice. File your reply. Same order.
In the meantime, stay on. उसमें
same order. Statement.
Item 31, Mr. Sanjay Kumar.
Nothing. My lord, this present writ application is for quashing the order as contained in annexure 8 and 8(1), my lord, by which order annexure 8 at page 26, my lord, by which order petitioner put under suspension and initiation of a departmental proceeding against petitioner, my lord, and annexure 8(1) is charged. My lord, may I permitted to read the first 3 lines of annexure 8 by which this petitioner was suspended. Page 26, my lord. जिला कार्यक्रम पदाधिकारी माध्यमिक शिक्षा बांका के जांच प्रतिवेदन दिनांक 929 दिनांक 31/7/19 द्वारा प्रतिवेदित किया गया है कि श्री खिरदर दास सोएंसु रहते उपस्थिति दर्ज किए जाने की जानकारी विद्यालय के लिपिक तत्कालीन श्री उमाकांत पंडित को थी, किंतु विभाग को जानकारी नहीं थी. ऑन द बेसिस ऑफ इंक्वायरी रिपोर्ट ऑफ डिस्ट्रिक्ट प्रोग्राम ऑफिसर, दिस ऑर्डर हैज बीन पास्ड. the memo number 929 dated 31/7/2019 is, my lord, Annexure 3 of my petition. तो इंक्वायरी का सब्जेक्ट ही अलग है और अलग सब्जेक्ट में हुजूर हमारे ही आवेदन पर ये इंक्वायरी सेटअप हुआ था कार्यक्रम पदाधिकारी द्वारा। हमने तत्कालीन प्रधानाध्यापक के खिलाफ कुछ आरोप लगाया था विभाग को, विभाग ने नहीं सुना तो हम लोकायुक्त के यहाँ गए थे हुजूर। उसके बाद ये इंक्वायरी सेटअप हुआ। इस इंक्वायरी में हम विषय वस्तु नहीं है। आफ्टर ऑल हुजूर मंतव्य में आया है पेज 20।
आप तो सबसे बड़े विषय वस्तु है, आपने तो कंप्लेन करी है
हुजूर, हमने कंप्लेन
तो फिर
तो हुजूर हम पर जो
विषय
चार्ज
और वस्तु तो दोनों आप ही है।
हाँ बिल्कुल हुजूर, हम पर जो चार्ज है हुजूर एक बार चार्ज देखा जाए एनेक्सर 8(1) में का एनेक्सर 8(1) देखा जाए कि वैसे सस्पेंशन मेरा 2 दिन के बाद ही डिपार्टमेंट ने रिवोक कर दिया, जो हम एनेक्सर 9 लगाए हुए हैं। हम आए हुए हैं कि डिपार्टमेंटल प्रोसीडिंग जो मेरे खिलाफ स्टार्ट हुआ है वो नॉनेस्ट चार्ज पे है और एनेक्सर 9 हुजूर 1 मिनट के लिए देख लिया जाए कि सस्पेंशन मेरा रिवोक हो चुका है।
नोटिस कौन आ रहे हैं दूसरी तरफ से? बांका You are the counsel?
Sorry, I was not instructed.
Shilpa Singh.
Shilpa, I am not.
DA 12. Yes, take notice. Copy दीजिए इनको. Reply भी file.
सब है सर। ऑलरेडी कॉपी ऑलरेडी सब मैं हुजूर का आदेश होगा कि मैं इनको भी पर्सनली दे दूंगा। तो हम
4 weeks
नंबर हम कल भेजवा देंगे, ठीक है? अब ले
Item 32, Mr. Nalin Kumar.
Lordship, kindly see annexure 6, page number 31. This is the mark sheet of DLED ODL. Lordship, page number 31, Lordship.
किस सब्जेक्ट की है? डिप्लोमा इन एलिमेंट्री एजुकेशन।
Lordship, petitioner, kindly see the marks of 3rd semester. Petitioner appeared but unfortunately petitioner declared absent in every paper of 3rd semester.
हाँ, 3rd semester, पेज 31 पे तो
3rd semester पर लॉर्डशिप प्रथम, द्वितीय और तृतीय यही 3rd सेमेस्टर है। साइड में मार्जिन में हुजूर देखा जाए,
प्रथम
द्वितीय नीचे, उसके बाद तृतीय है हुजूर। 3rd सेमेस्टर में इसके सारे पेपर में हमको 0 फेल और एब्सेंट भी दिखाया गया हुजूर।
एब्सेंट फेल
जी
यस।
एक्चुअली हुजूर हम इसमें पार्टिसिपेट किए हैं बट हुजूर हमको एब्सेंट दिखा दिया गया। हम हुजूर RTI भी डाले।
So how is this board going to reach to this conclusion whether you have passed or whether you appeared or not appeared?
हुजूर हमने RTI डाला।
बोर्ड में जाइए, डिग्री लीजिए।
हुजूर हम टर्मिनेट हो जाएंगे हुजूर। RTI भी हुजूर डाला, इन्होंने नहीं रेस्पॉन्ड किया हुजूर। उसके अलावा हुजूर हम रिप्रेजेंटेशन भी दिए, नहीं रेस्पॉन्ड किया।
So how we presume that you have appeared?
हुजूर हम अपीयर्ड किए हैं हुजूर, हम ऑन एफिडेविट कह रहे हैं हुजूर।
आप कह देंगे और हम मान लेंगे। You prove it in a competent court. This is not the court. We don't record evidence here.
हुजूर काइंडली रिप्रेजेंटेशन के लिए डिस्पोज कर दिया जाए हुजूर। हम रिप्रेजेंटेशन देते हैं हुजूर, यदि नहीं
मना कहाँ है?
हुजूर रिप्रेजेंटेशन पर नहीं रिस्पॉन्ड कर रहे हैं ना हुजूर। एक टाइम फ्रेम हुजूर रिजनेबल कर दिया जाएगा हुजूर। एग्जामिन कर ले हुजूर, फेल होंगे तो ऐसे भी हम टर्मिनेट हो जाएंगे हुजूर। का अताउर रहमान केस में ऑर्डर है हुजूर।
Anything else? The petitioner by way of this petition challenges the final statement of marks issued by the Bihar School Examination Board, whereby in subject of diploma in elementary education, open distance learning, petitioner has been shown to have failed and absent the 3rd semester. Learned Counsel submits that the petitioner has appeared in the examination and has been wrongly shown as absent. It is further submitted that the petitioner has represented to the board.
लॉर्डशिप एनेक्चर 4 से हमने बोर्ड को आरटीआई डाला और हुजूर एनेक्चर 5 से एससीआरटी को भी एप्लीकेशन दिया। बोर्ड ने हमारे आरटीआई के एप्लीकेशन को ट्रांसफर कर दिया एससीआरटी के पास, तो एससीआरटी को भी हमने एप्लीकेशन डाला।
Board represented to the board and also submitted RTI application. But the same have remained unanswered. Para. This court is of firm view that the question regarding the petitioner being absent or present in a particular examination is a subject matter of evidence and cannot be adjudicated in red jurisdiction. However, as the petitioner has already submitted presentation to the board, it is directed that the board shall
हुजूर रिप्रेजेंटेशन मेरा एससीआरटी को है हुजूर।
RTI को है हुजूर, it should file a press representation before the secretary.
किसको दिया आपने SCERT को?
SCERT एक्चुअली हुजूर
बोर्ड की जगह आप SCERT कर दीजिए, स्टेट काउंसिल ऑफ एजुकेशनल रिसर्च एंड ट्रेनिंग। But SCERT shall examine the representation and if required, opportunity of hearing may be also provided to the petitioner and a speaking order be passed within a period of 3 months. If the petitioner is further agreed, he may take up the matter before a competent civil court to prove that he was present during the present and appeared in the examination.
रिप्रेजेंटेशन डिस्पोज होने तक हुजूर लॉर्डशिप तब तक के लिए हुजूर मैटर स्टे कर दिया जाए।
Next.
Item 33, Mr. Prakash Mahto.
May I read it? My lord, case of the petitioner is identical to the case, my lord, that is annexure 8, my lord.
My lord,
annexure 8 may kindly see.
Online counter affidavit was filed, my lord. And the hard copy is here, my lord.
The counter affidavit is said to have been filed in the registry. It has been filed in the registry, directed to place the same on record just after.
Item 35, Mr. Asit Kumar Jha.
Order under challenge lordship annexure 10 of the writ application. Petitioner is a Jilla Parishad and employment unit lordship and is agreed with annexure 10. Brief fact of the case is lordship. The matter relates to the employment of librarian in the secondary higher secondary school.
Annexure 10 at page?
At page number 68 lordship. Order passed by the state appellate authority. Direction has been made to the fresh reconciling.
What are the directions?
Para 15 is the operative part. In result, the impugned order is upheld and appeal is dismissed. The authority feels that the other 4 candidates who are said to have appeared after 12 should not be excluded from consideration only because they did not come to the district authority or state authority for redressal of their grievances. Therefore, the authority orders that all the 5 candidates who are said to have appeared after 12 should be included in recounseling. After this recounseling, the employment unit take a fresh decision about the employment in accordance with the approved merit list. But before making a final decision, it will notice all the candidates, and after hearing them in this regard, after hearing the candidates who are found fit for employment will be appointed, and if some candidates who had been appointed earlier but does not qualify, after recounseling will be removed from service. This entire exercise will be completed within a period of 2 months, and it will be the personal responsibility of the Deputy Development Commissioner, who is the appellant of this case, to ensure the compliance of this order of the authority. With this direction, this appeal is disposed of. Lordship, submission is that the respondent number 2 was one of the candidate who, without impeding the selected candidates, filed the appeal before the district appellate authority, Lordship, and order was in his favor. Against this, the petitioner moved with the state appellate authority. Then this order has been passed.
So that order was passed without hearing the selected candidate.
Lordship. Although in his appeal he has mentioned that the 5 candidates who have got the lesser marks to him are selected, but the respondent to number 2 never make them the party in this appeal. I have annexed, Lordship, that is at page 8 series, Lordship.
But on their behalf, that cannot be a ground for you. You were party. They have not come before the court. So far as you are concerned, what do you have to say for yourself?
Lordship, submission is that if I will go through the reconciling all the candidates which are working earlier from the last 8 to 9 years.
They will have to be removed if they have been wrongly appointed. A procedure which you have not followed earlier and appointed wrongly persons. That is what the court says. With the occasion of the order being interfered with. Is rightly passed it or not?
My humble prayer that the natural justice may prevail.
No, that is not for you to be bothered about.
Again, they will come. Then another round of litigation will.
Let them, if they come. How is the state on that matter? Your Nagar Parishad, Zilla Parishad, being so anxious to save their appointments and not give this person opportunity. This has come on record that
Lordship, we met the allegation.
You have not included them on the ground that they came after 12.
No, Lordship, he met the different allegations before the different. First of he said, Lordship, that since he belongs to the different districts, so at the time of counseling, I was not permitted to appear for the verification of the letter. Then he gave the another version that the.
This is your version.
No, Lordship, this is the versions of.
This is your version before the appellate authority. You were the appellant.
No, Lordship.
You were the appellant.
Lordship.
You have said
Lordship.
That we had denied him because they were all after 12. They were not there.
This is my version, Lordship.
That has been held to be bad by the state appellate authority.
Lordship, that has been held bad.
How it is wrong? From where did you get this time of 12? After 12 you will not allow, 12 before 12 you will allow.
Lordship, what has happened, Lordship, the selections of teachers and librarians, both were going on. Education department issued the guidelines.
Did you inform the candidates that if they come after 12 they will not be considered?
No, Lord, that is nothing in the record that is.
Then, had there been a condition, well, that could have been one of them.
Only submission that if this will go, everything will.
What everything will go?
Will be. Everything.
What will go?
All the first exercise.
He has to be given appointment. You give him. You have taken the matter to the state appellate authority. You have brought it here. Those other teachers, though none of them has even thought of even challenging that order of district appellate authority before the state appellate authority. Is the occasion? Illegal appointments being saved by the commission. Why should we not impose a cost on this Deputy Development Commissioner? What is his personal interest?
No personal interest.
Then?
Only in the inquiry.
The internship dispute?
Only in the inquiry report.
And they rightly say that you can't deny people from even, and they are meritorious, higher meritorious candidates. This is also has come.
Only thing is, Lordship, that the time which was fixed by the employment committee from the, it did not come the time, and another allegation was that.
That is what we want to know, that time which you have said.
Lordship.
Was it published? Was it informed? No.
No, it was not.
Then your employment committee sitting there thinks that all right, because people whom we were interested in have already come, others will not come. इस तरह से तो हो नहीं सकता ना. You have to be very fair. You are a welfare state.
Lordship, that is true. I should be the fair.
That is not transparency also.
Only by prayer is, Lordship, that the notice they issued the respondent number 2, and after hearing
For
all
what? For what?
Since his original allegation was that he was discriminated on the ground that he comes from another district, Lordship. This was his first allegation, Lordship. But in the appellate tribunal, he took, apart from other grounds also, Lordship.
देखिए, the Nagar Parishad through its
Jilla Parishad, Lordship.
Jilla Parishad through its Deputy Development Commissioner cum Chief Executive has preferred this writ petition, assailing the order of the State Appellate Authority, whereby their appeal preferred against the order passed by the District Appellate Authority was rejected. Learned counsel for the petitioner submits that the direction of the District Appellate Authority for recounseling would result in removing the teachers who have been already appointed, and the judgment passed by the District Appellate Authority as confirmed by the State Appellate Authority is erroneous. I have considered the submission. The selection was to be conducted for the post of librarian in different secondary and higher secondary Zilla Parishad schools. The respondent preferred an appeal before the District Appellate Authority, Begusarai, pointing out that he possessed 60.36% marks, but in spite of presenting himself for counseling, was not allowed to participate on the premise that were not allowed to participate, while persons having lesser merit were offered appointment. The respondent alleged partiality and a high-handed action taken at the level of the petitioner employment unit, employment committee, who deliberately and intentionally did not allow the petitioner to participate in the counseling. The District Appellate Authority para karke थे, allowed his appeal with directions to the Zilla Parishad Niyojan Samiti Employment Unit Committee to hold counseling of the respondent afresh and proceed to complete his process of appointment strictly in accordance with merit list. It also allowed the Zilla Parishad to make corrections in the final list of selected and appointed candidates of librarians the petitioner preferred an appeal on the ground that the employment committee, its employment committee took a decision to allow only those candidates who had appeared up to 12. And as the petitioner appeared after 12 o'clock, he was disallowed, respondent appeared after 12 o'clock, he was disallowed to participate.
Respondent number 2, Lord.
Para. The State Appellate Authority has examined the order passed by the District Appellate Authority and also found that there were 5 candidates who had been deprived from participating in the counselling on the basis of a decision taken by the employment committee not to allow candidates who had appeared after 12 o'clock. It also noticed that no time was prescribed for counselling and therefore held such action to be illegal and unjustified and therefore ordered that all the 5 candidates who had appeared for counselling should be included in the re-counselling and the employment unit would take a fresh decision about employment in accordance with the approved merit list. Para. The grievance of the petitioner before this court about such order resulting in further litigation is wholly misconceived. The affected persons who are also employed with the petitioner have not challenged either order of the District Appellate Authority or nor they treated themselves as party to the before the State Appellate Authority. The decision of the State Appellate Authority is wholly justified when it allows all the candidates who appeared for counselling to participate in the re-counselling. The order of the District Appellate Authority has been modified to the said extent, which appears to be in consonance with principles of Article 14 of the Constitution. No interference is therefore warranted in the order passed by the State Appellate Authority. Writ petition is accordingly dismissed.
Item number 36. Company. Next.
Lordship, I have got a prayer. Yesterday, I had a case which is descended on 15th of February, but I had gone through the file. It has descended to 15th of February because it could not reach yesterday. Now the problem is that they have submitted their reply copy, means counter, to this court, but I have not been served copy because of the corona. So if your Lordship give an instruction to give me a photocopy, then I shall be in a position to give a rejoinder. Give an instruction. हाँ दे दो. Yeah. Lordship. हाँ बोलिए.
Hearing of 4 of 2000 was completed last week, my lord. I have filed additional written statement. I have given that on behalf of RBI.
I have yet to look into it.
Petition, serial number 81, company petition 3 of 1984, item number 1, OLR number 4 of 2023 and 7 of 2023.
What is this report?
In terms of order dated 10th, my lord, I have filed list of quarters who are occupied, detailed list, all
This-
complete list.
This 4 of 23.
Yes, my lord.
All right. The report has been filed by the OL. In terms of the order passed by this court, dated 10/11/22. The empaneled valuer, Mrs. Bhartia and Associates, has been further appointed to evaluate the said quarters. As per the report, total number of quarters are 1,738, which have been bifurcated into 7 categories by the OL. The said report is taken on record and accepted. Further report to be filed by the OL. What is this 7/23?
Further, I have filed on 20th January, my lord. We want to give a notice to all the occupants of quarter for vacation.
What is the order of the division bench?
Division was yesterday taken, not, order is not yet, order is awaiting.
But what is it? What
They have
is
given 6 months time, 30 people, 30% have gone to appeal.
They have been given 6 months time?
Yes.
So you will have to
So
inform.
I have drafted notice on that way.
On that basis only?
Yes. That outcome of that case, they will, my lord, draft notice is page 41.
Well, sir, what I would suggest is we
Yes.
must incorporate that order. Once that order is of previous date, it has already been passed yesterday. And if we pass any
Yes,
order today,
yes, ma'am.
that may be in contradiction.
Yes, my lord.
And further, since 30 persons have been
My lord, our counsel representing division bench, he may allow to.
With the Lordship's leave. Yesterday, the company appeal was taken up before the Honorable Division Bench. So those outsiders who have filed that, out of them 26 people have furnished an affidavit that by 30th of June, they will vacate their respective premises. An official liquidator has been granted 4.5 months' time for completion of valuation and option sale of those 30 quarters.
Before that date or afterwards?
No. These are two different things.
See, one is when they vacated by 30th June.
Well,
see, we directed that they should first vacate and then it will be auctioned.
Yes, my lord. That the Honorable Chief Justice, my lord, were of the view on the first occasion. They pleaded that we should be granted some accommodation. The Honorable Chief Justice were of the view that all right, please furnish an affidavit that by 30th of June you will vacate the premises.
So after 30th June then we will have 4.5 months?
No, Lordship.
Or is it prior to that? How can that be? Auction cannot be done unless the house is vacated.
Honorable the Chief Justice were of the view, my lord.
Has that been incorporated?
No,
in the order?
that is not incorporated in the order. Honorable Court were of the view that you proceed with the auction. And in the auction notice...
Let's see what comes in the black and white. Let's see the order. It is the OLR has been filed seeking permission to publish a notice for for vacation and auction.
Yes.
However, it is informed that the order passed by this court dated 14/10/2022 is a subject matter of LPA.
Company Appeal number 8 of 22.
Company Appeal number 8 of 22, which was wherein some orders have been passed by the division bench. Let orders passed by the division bench be placed before this court before further directions may be issued, before any further directions are issued in this OLR.
Next week?
Let's start. 1 week.
Item number 2, OLR number 82 of 22, 91 of 22, and reply of JBL.
My lords had heard this on the last.
Okay, this is the same one.
Same lots, 2 plots, possibly 1/5 being sold for 17 crores. My lords, your lordships had asked me to seek instruction from my client, my lords. My lords, I have got those instructions. My lords, we'll proceed to place our case. Rest is to your lordships.
All.
My lords, on the last occasion, we had gone through all orders, and I know your lordships has a great memory, my lords, though I may be falling short on that. One particular order, valuation report order, which is contained in order dated my lord, order dated 25/2011 being order number 422. On the last occasion, your lordships had directed the OL also to have it.
21
And my some
रिकॉर्ड पर है ऑफिस करंट चल रहा था तो करंट का 11 का बोल रहे हैं पुलाना
my lords, I understand.
सर ऑर्डर है कि 11 वाला वैल्यूएशन का
Would it be possible that we take up the matter next week?
My lords, 16th I was going to make a very humble prayer, my lords, on account of my personal difficulty, my lords. In fact, your lordships had been pleased to fix personal appearance of the same OL on 16th. My lords,
if there is a personal difficulty, all right, then we'll keep it on 23rd.
My lords, could it be on the next week, my lords? They are marriage season, my lords, marriages in the family. So, it could be on first, yes.
23rd?
23rd, my lords, I'll be again on 2 marriages in the family, my lords, marriage season, and we
Then we will go on 16th.
16th March.
Yes.
Lords, could your lordships...
The order sheets, orders passed by the company in relation to company petition 3/84 shall be kept ready for perusal of this court on the next date.
My lord, in that same OL matter, your lordship has fixed 16th. That fight. But presence is there, my lords. So if your lordships could indicate, I have taken the consent of the other side, Satyabir Bharti.
Today we can't be passing, it's not listed. On 16th we'll pass an order, we'll fix it on 16th.
So my lords,
somebody from your...
he will be here. But will he be required to be present, my lords, on 16, the OL? That's the order of it.
Not required, he'll just remind us so that it is listed.
My lords have already ordered for his personal appearance.
All right, so we will extend it.
Also, I have traced the case laws from 66 to 2015. That's a good period, my lords.
Give us a companion.
Because one judgment I will be referring which contains discussion of all that, and that to a DB judgment of this court.
Okay.
Item number 3, IN number 329 of 2022.
Because the petitioners before your lordships were allotted this bungalow by virtue of different orders of this honorable court. The only limited prayer is, Millers, that Millers have passed an order categorizing it in two sets by order dated 14/10/2022, one being the employees and the other being the outsiders. Now, out of 5 Millers, if your lordships will have pleasure to look at page 53 of this IA, there are 5 allottees who are allotted with the different orders that has been marked. Page 53, Millers, Credential 15. These are the 5 quarters. Lordships have got that. These were the 5 quarters allotted to these 5 occupants. 4 of them are petitioners before your lordships in this IA, and they were allotted by different orders. My only prayer was, Millers, that these allottees be treated as not outsiders, rather in the category of employees, so that there can be an option within itself, because they had been paying rent and they have been acknowledged by this honorable court that they are the residents, so they are not either trespassers or encroachers in strict sense. So their category has been made as outsider, allotted by the honorable court, by the OL. This is the limited prayer in this argument.
In what capacity were you allotted these quotas?
They were either in service and then district administration, or were teachers or professors in the college. They had made an application before this honorable court and subsequently they were granted.
Have you placed these orders on record?
Your lordships, these orders are, Millers, with regard to all these 4 applications, Millers, and Annexure 2 is the first order, wherein during the pendency of the proceedings and we are not aware, the DM had allotted, the SDO had allotted, and then the showcase was issued. Annexure 2.
First is of 9/10/98.
Plus Annexure 2 at page 18.
Yes. So this page 18 is for which one?
Petition number 1. Let's say she is widow of late Vishwanath Singh. Then Miller's page 29 is in relation with the second petitioner.
Page 19.
Page 29 minutes.
What is this at page 19?
Page 19 is the subsequent enhancement. Page 19, just a minute. Page 19 is the enhancement of the rent from 200 to 800. And page 22 is the demand made by the official liquidator, your lordships. Earlier also they were treated as encroachers, and thereafter the order was recalled, which your lordships will find at page 24, last paragraph.
And then for this, then you say page 29.
Plus, I will draw lordship's attention to page 24. Plus, in the earlier eviction proceeding, Millards, when these petitioners were also dragged into, they came before this honorable court, Millards, and by the order dated 8/7/2004, Millards, order with regard to such petitions was recalled, which your lordships will find at page 24, last paragraph. In relation to two petitioners in this case, SOB 6 and SOB 17. And in relation to Millards, the second petitioner, the allotment your lordships will find at page 29.
Lalmuni Kumari was not allotted the house by the High Court, but by the official liquidator.
Official liquidator.
You have said that he was allotted by the High Court.
But here, subject your lordship will see at page 29. This is allotment of quarters bungalows of Rohtas Industries Limited, so and so company in terms of the High Court's order dated 22/11/2002. This allotment letter has been issued in pursuance of the order which has been passed by this honorable court on 22/11/2002. At page 29, because that reference is there.
So Lalmuni Kumari was also allowed 2004. So what? Now they will have to vacate.
Yes, we will vacate, but the only.
But they can't be shifted to that category.
Because that was the only request. Because since we are not actually a trespasser or encroacher in a strict sense, therefore, at least they should be treated as a group where auction should be within the circle itself, lordship. They had been residing so long and had been paying rent to this honorable court, which was acknowledged.
They are only tenants. They are all right. They have been there for last 10 years, 20 years.
That I accept. That is, but the only
the right of a tenant cannot be equated to those who were original allotted from the company.
Once your lordship considered the right of the employees and the legal heirs, that's a request.
Employees, we have just said, because their claims are pending. There are certain claims which they claim. Though of course, you will say that we have already completed everything. They're all right. What preferential right is there for them?
Some kind of preference, because they
don't have any preferential right. And the way you have been allotted, you were allotted by the OL, who was in the court does not find any reason.
Millards will kindly see that page 29 minutes. This is in reference to some order which was passed by this honorable court.
This allotment at page 29, the subject itself says the order dated 22/11/2002.
Yes, what do you say about this?
My lord, all are treated as outsider because they are not ex-employee. There is two category only, ex-employee and outsiders. Whoever the allotment was made, they are not ex-employee.
They have said the outsider allotted by the Honorable High Court. That is the category which they have created, but that falls within the category of outsider.
That the case of 30 people who preferred the appeal, they are also outsider. They have been allotted by the Honorable Court in the year of 2007.
Go there before the decision. If that is so, you guys, you fall in that category. You file your reply, we will.
Yes, ma'am.
By that time,
if they fall in that same category, we'll give them that same benefit.
All right.
2 weeks. 1 week के बाद रखा, 2 weeks के बाद.
2 weeks, ma'am.
Serial number 82, Company Petition 5 of 1995, item number 1, OLR number 130 of 2020.
Valuation report. Valuation report.
Valuation report.
Report of Bolia property soon very soon. It's a large.
Has been filed. The valuation report has been placed on record. Dated 22nd, 12/22, wherein the official valuer has conducted valuation of landed properties of the company in liquidation at village Daranagar and Singhpur.
No, my lord, it's a
At village Garden.
different places. Different
At
places.
different places. The OLR is accepted and the OL
Sale date is to be fixed.
Allowed to publish sale notice for the sale of landed properties and building structures of the company in liquidation
Not building, my lord, only land.
at Bolia.
Yes. Bolia.
Baulia. The same shall be published in 2 newspapers commonly circulated in the state of Bihar as well as Jharkhand. One in Hindi and another in English. Further report will be filed.
Sale date, my lord, 16th March. Fixed in the sale notice. 16th March.
Sale notice sale shall be fixed for 23rd kar do.
Okay.
23rd March.
Serial number 83, company petition 5 of 1999, item number 1, IN number 34 of 2022.
Lords, this is an application as for recall of an order, my lords, dated 10/11/2022, my lords.
10/11?
2022, my lords. That is page 9, my lords, annexure 1.
Why do you want it to be recalled?
Lords, I am the only secured creditor, my lords, and my dues, my lords, should be ranked, my lords, pari passu with the workmen, my lords. Pari passu, my lords, in my respectful submission, only means that, my lords, it should be on pro rata basis given, my lords, to the secured creditors and the workmen, my lords.
Show the provision.
529, my lords, noted. So therefore, my lords, I am.
Please read it.
I'll just place it.
Good.
I'm just placing. I'll
We
just.
know. Therefore means what?
Notwithstanding anything contained in any other provision of this Act or any other law for the time being in force, in the binding of the company, workmen dues and workmen dues and debts due to secured creditors, to the extent debts rank under clause C of the proviso to subsection 1 of section 529, pari passu with such dues shall be paid in priority to all other debts. The debts payable under clause A and B of subsection 1 shall be paid in full unless assets are insufficient to meet them, in which case they shall abate in equal proportion, my lords. So therefore, my lords, my only contention is that I being the secured creditors and, my lords, in terms of the advertisement, and I have submitted the proof of my claims which was adjudicated, my lords, and if my lords may take page 15 of the application, my claims are, my lords, of more than 22 crores, my lords.
Yes.
Shall be placing the
What's the law on this?
Law, my lords, has been categorically decided, my lords. I'll be relying on, my lords, AIR 2005 Supreme Court, page 1814, my lords. Paragraph, my lords, 20.
Okay. This is AIR 1984.
2004. 5 minutes.
2005.
Yes, minutes. Page 1814.
1814.
Yes.
Para?
Minutes, para 22 onwards, minutes. 22 to 25 minutes.
Yes.
Let me just place it.
What does it say?
The language, may I just place it?
Whatever.
The language of section 529A is also clear and unequivocal in terms of where workmen due or debts due to secured creditors to the extent such debts rank under clause C of the proviso to subsection 1 to section 529, pari passu with such dues shall have priority over all other debts. Once the workman's portion is worked out in terms of proviso C of subsection 1, indisputably the claim of workmen also secured creditors will have to be paid in terms of section 529A. This court in Allahabad Bank held, Millards, they are just placing, and now to the operative portion, paragraph 24, I'll just be. While determining point number 6, however, a stray observation was made to the effect that the workmen dues have priority over all other creditors, secured and unsecured, because of section 529(1)(a). Such question did not arise in case as Allahabad Bank was indisputably an unsecured creditor, because this is, Millards, with reference to another.
Then
such an observation thus was neither required, para 25, neither required to be made keeping in view the fact situation obtaining therein does not find support from the clear and unambiguous language contained in section 529(a)(1)(a). We therefore have no hesitation in holding finding of this court in Allahabad Bank Supra for aforementioned extent does not lay down the correct law. The court wrongly placed reliance on National Textile Workers Union of India and others, P.S. Ramakrishnan and others, 1983 1 SCC 2. The question which arose therein was also with regard to right of workers to be heard in winding up proceeding. The said decision therefore was not applicable. And Millards, after this, Millards, in 2013,
yes,
there's another, Millards, section 2013 volume 1 SCC page 462, Millards, paragraph 33 I am placing reliance. Section 529A of
2013 volume 1 SCC?
Yes, Millards, page 462. Section 529A of the Act opens with a non-obstante clause. Paragraph 33 I am reading. Giving the workmen dues of the secured credit, giving the workmen dues and secured creditors due as defined under proviso to section 529(1), an overriding effect over other provisions of the Act as well as any other law in matter of priority of payment of dues. The application under 529A of the Act is not dependent upon any other provision of the Act, including section 529 to the extent specified in 529(1) proviso clause C. So it is not dependent upon limitation imposed by any other law for the time being in force, including section 47 of the Insolvency Act. The non-obstante opening words of section 529A are intended to give precedence to the overriding preferential payments. In contrast, the preferential payments as contemplated under section 530 of the Act, this non-obstante language attains even greater significance as it in no uncertain terms provides that 529A shall have effect notwithstanding anything contained in any other provision of the Act or any other law for the time being. No law, including insolvency law, can undermine the application under section 529, read with section 529A. Thus, provisions are exceptions to all other laws in force. And therefore, again, my lords, in paragraph 55, the provisions laid down in
Andhra Bank versus official liquidator, the 2005 judgment, my lords, which I was referring, that has been reiterated, my lord. I just 462.
40.
462.
Para 33 is of the minority view.
That's this paragraph 21, main reliance, my
Then
lords.
you were relying upon this para 33. It is of a minority view, Justice.
Para 55, my lords, may take.
They are all from para 28 onward. They are all minority.
My lords, para 55 may take, my lords. They is relying on the Andhra Bank judgment, my lords.
That is the judgment of the. You understand what is a minority and majority?
Yes,
view?
yes, I do understand, my lords. I do
So
understand.
this is a minority view which you were reading just now.
Because this is
It is not the majority view.
But I am placing reliance on the 2005 judgment.
But that has been. This is a 3 judges bench.
This is also a 3 judge bench.
But then they have
2005.
subsequently examined it again.
Examined, but 55, my lords, is there reiterating the view.
Let us see what the majority says. You are supposed to read the majority view, and otherwise you should inform the court that what you are reading is a minority view.
My lords, that
You
was.
can't directly say that
My
you
lords,
will.
that was.
If I had not asked you,
on my part.
if I had not asked for to give me a book,
No, my lord.
I would have just accepted what you are saying.
Lordship, that was a mistake on my part. I should have placed that minority view. But in any view of the matter,
Mr. Lawyer, this is a very big slip.
I apologize, my lords. I don't wish to, my lords, anyway. My lords, I am also trying to just persuade my case, my lords. I don't wish to mislead, my lords. I deeply apologize.
No, I know, we know, but you don't know the approach in the courts, High Court, the Court of Record. You have to be very cautious what you are saying.
Lordship, I'll keep that in mind, my lords, the next time.
One of your Chief Justice, who was a judge from Rajasthan, he took objection and initiated contempt proceedings against one lawyer for only mentioning that there is a judgment which is overruled. Said you can't even mention about an overruled judgment in the court. You can't influence the view of a judge by an overruled judgment. That amounts to influencing.
My lords, yes, I do understand, my lords. Therefore, I am deeply apologizing, my lords. I don't wish to.
ठीक है. Always a learning process, I believe. This is for your knowledge also. What is happening here and what is normally happening. I had taken up this because I remember clearly that I have seen this judgment. The right of a secured creditor is only with respect to the property which has put on security to the secured creditor.
They have opted outside the
Say, suppose there are 10 properties of a company and the property which has been put as a security for obtaining loan, to that extent the security
Yes, madam. Yes.
relating to other properties are available for unsecured person.
But
so far as workman is concerned, it has a right against all the properties.
in all properties. But
That is why I said that you first.
But in this case, my lord, we have realized the asset in which they have charged.
On all the assets?
Yes, madam.
Mostly, my lords, the properties are all movable, my lords. They are not immovable properties available with this corporation.
इसमें immovable भी था.
Immovable है.
फैक्ट्री.
इसमें मॉर्गेज डीड नहीं बनाना पड़ता.
What about the movable properties? Movable part?
Movable also is for a factory in Koderma. In all movable and immovable, they have charged central bank.
Have you seen that? Have you verified it?
You can file an affidavit and reply also after verifying.
So in your view, the pari passu charge means that it has to be equally shared.
Not equally on the
What is
ratio.
the meaning of pari passu
Pari passu
charge?
that has also been defined. The calculation is 529. Illustration is there. In this illustration, suppose security valuation of the security of secured creditor of a company is 1 lakh. 529. The value of the security of secured creditor of a company is 1 lakh. The total amount of the workmen dues is 1 lakh. The amount of debts due from the company to the secured creditor is 3 lakhs. The aggregate of the amount workmen due and amount of debts due to secured creditors is 4 lakh. The workmen portion of the security is therefore 1/4 of the value of the security, that is 25,000.
All right. Okay.
My Lord, in view of this application, we have not yet released amount.
You want to file a reply to it?
No, we have not yet released. We have kept abeyance in view of the order dated 10th/11.
All right. So what is the amount due for the? Can you file a reply and give us what is the details?
Yes, ma'am.
Learned and the OL shall file a reply and give out the details of the amounts as claimed by the secured creditor as well as of the worker.
At page 14.
We'll clarify.
At page 14, though, my lords, I have annexed the adjudication. My lords may just have a look at that.
We want actually his reply.
Yes. I am not disputing. At page 15, the quantification is there.
AIR 2005. All.
Item number 2, IN number 35 of 2022.
Lordship permission. This application is for condonation of delay in filing claim form 66 for the employees provident fund due amount against an establishment, Messrs. Industrial Raw Material Depot Gamharia, Jamshedpur, a unit of Bihar State Small Scale Industries Limited, Your Lordship. There is a proceeding before the Honorable High Court of Jharkhand at Ranchi for recovery of the there is a proceeding for recovery of the amount, Your Lordship, and some petitioner filed a writ petition by the writ petition number civil number 1555 of 2008 before the Honorable High Court of Jharkhand at Ranchi, and after proceeding, the last order has been passed by the Honorable High Court of Ranchi, Your Lordship, which is annexed as Annexure 13, page number, the concluding part is page 14, Your Lordship.
How much dues which you have collected in year have you distributed? Can you give us a detail? Anywhere in any state or in India, the total amount which you collect as so-called dues of the workers, which has, out of that, how much have you distributed or given back to those workers?
I have to seek permission, instruction, Your Lordship. I have not detail about that.
They've already got leave, my Lord, in 2019 to file it. They have got condonation of delay, but they have not yet filed.
That is,
they already got
yes,
the order of this court.
Yes, Your Lordship.
In 2019.
That
and
is,
then also they did not.
No, the amount has not been collected till date, Your Lordship. Bihar Emporium, Dak Bungalow, Patna ka tha wo, Your Lordship. That establishment is Bihar Emporium, Dak Bungalow Road, Patna, Thalake, Your Lordship. And against that, I have filed IA number 26 of 2019 for recovery of the amount, EPF amount, Your Lordship. And that
was on
IA number 26, Your Lordship, page number, Annexure 3, Your Lordship, page number 16. IA number 26 of 2019. This interlocutory application has been filed on behalf of PPFO for condonation of delay in filing claim in Form 66 before the learned official liquidator. Learned official liquidator stated that he has no objection if the delay of about 2 years in filing the claim is condoned. In the above circumstances, the delay in filing claim in Form 66 by the EPFO is hereby condoned. Let learned official could take further steps in the matter in accordance with the law. That amount has, as per instruction, Your Lordship, that amount has been deposited. Has not been deposited till date, Your Lordship. And when the order
you
has
have submitted your claim.
I have submitted.
You have submitted for which you were granted when the delay was condoned.
No, Your Lordship. For this purpose, no, never.
So what is your claim?
The claim is, Your Lordship, 13 lakh 90,691. EPF amount has been the EPF dues, Your Lordship.
For?
Against Industrial Raw Material Depot Gamharia.
For what? For non-payment of?
Contribution amount, employer and employee.
Employer and employee. That
Yes.
contribution amount has not been deposited. Have you distributed it to the employer?
So for Your Lordship, employer...
Their contribution part, have you distributed it?
No, Your Lordship, employer...
Which are the detailed employees for whom you are demanding this amount?
The details I have to seek instruction, Your Lordship, for getting the
Are you understanding
details.
what this court is asking you?
Yes, Your Lordship.
Yes. We can't be letting it remain with you. Then we will ask you to distribute it to them. Have you ever even published a single notice to the employees that your amount we have recovered from the concerned firm?
That amount has not been recovered till date, Your Lordship.
That is one part. So far as this company is concerned, it has gone into liquidation. I am asking you about those companies which are functioning. You recover the amount from those companies when they do not deposit their dues. Their share they don't deposit sometimes. So you recover it along with interest. Now after you have recovered it, do you distribute it?
Yes, Your Lordship, there EPF account, if there is an EPF account and that the amount will be deposited online in the EPF account, Your Lordship, of the employee.
Penalty भी लगाते हैं, 7 में लगाते हैं ना, under 7, section 7.
14B में penalty.
14 में भी लगाते हैं, 7 में भी लगाते हैं.
7Q interest. That is statutory, Your Lordship.
That is all statutory. It is all statutory. We all know it. But we would like to know from you whether you distribute it further or not. Ask your officers and tell us.
To seek instruction. So far, details of employees. So far, detail of employees is
You know
concerned.
the amount which is lying in the PF. And that is why the Supreme Court, even I had the occasion to pass a judgment with regard to payment of the dues to the workers and all.
So far, this concern is concerned, I have to seek instruction and the
Get the instruction. In the meanwhile, you file your reply. Reply be filed to the IA. List again. 3 weeks.
Serial number 84, company petition 21 of 1999, item number 1, IN number 800 of 2014, counter affidavit and related matter.
My lords, in this learned senior counsel Sri L.G. Sanjay has to assist. He is not giving well, my lords. He was though in the court for the first half, but due to fever, he has left for the second half. Lordships.
फिक्स किया गया था लॉर्ड्स, इसको लंबा एडजस्टमेंट दे दीजिए. फिक्स किया गया.
It was fixed for hearing, but as he is not well, my lords.
For due to personal reasons, counsel for the
Respondent, my lords.
respondent is not available. List this case again.
23rd.
On 23rd March.
23rd of this month, if it is possible.
Let him get well.
Because, my lords, at his instance, my lords, the only difficulty is, my lords, that we have paid the dues, we want the company to revive, and, my lords, a portion of land is being enjoyed by him. So, therefore, my lords, every pleading is deeply okay.
Serial number 85, company petition 11 of 2002.
My lord, with my lord's leave, in another connected original criminal miscellaneous was also posted. The accused is personally present. Personally.
Is this connected?
No, this one is
The earlier one?
Earlier. Sir.
इसमें लॉर्डशिप 2010 के बाद कुछ
Yes, take.
डायरेक्शन नहीं आया ऑफिस को कि अपील में क्या हुआ. No one informed to the office lordship.
Can we check? To check what is the present status? Civil appeal number. अभी रुक जाओ. Yes, इनकी फाइल.
Original criminal miscellaneous list हुआ था 9th के लिए फिक्स हुआ.
नंबर बोलिए ना.
3 of 90.
This is item number.
4 में ओरिजिनल criminal miscellaneous था ना.
नहीं 84 में नहीं 84 में तो
83 में.
नहीं 83 में नहीं.
कनेक्टेड मैटर मेंशन किया है वो लिस्ट.
नहीं वो अलग चला गया.
3 of 2010.
आज है.
आज लिस्ट होने का बात था इसीलिए वो पर्सनली.
नहीं वो लिस्ट हुआ था अलग हो गया.
अच्छा अलग.
नेक्स्ट डेट हुआ लॉर्डशिप. आज नहीं.
नेक्स्ट डेट. ठीक.
Yes. उसके बाद next.
Serial number 86, company petition 14 of 2002, item number 1, IN number 112 of 2022, affidavit on behalf of respondent.
This is the contempt matter, my lord, with respect to a property in Dehradun.
Yes.
And these lordships were pleased to issue notice upon them. After that, my lord, they filed an affidavit that permission for registration of sale deed they have granted. There were twofold directions in the earlier order, my lord, in which demarcation of the property was one of the categorical direction of this honorable court, and registration of sale deed. So sale deed draft we have filed with the learned official liquidator. It's in course of vetting. But so far demarcation is concerned, even learned official liquidator had also written to the district magistrate Dehradun in the year 2021 that demarcation is very important, please help. But no action was taken. Today also nothing is being done. And we have represented on 9th of January also for demarcation. We have brought all the facts in our rejoinder. My lords have been kind enough to grant us time to file a rejoinder. I have filed it.
Where is the rejoinder? Yes, sir. Who appears?
Lordship, Mr. Vikas Kumar has to assist your Lordship. He is on let's before DB1, my Lord. Simply pass over for the day I was speaking.
Next week.
Obliged.
For the respondent is not available.
I have annexed the photographs, my lord, the condition of land site. There are so many encroachers over this plot because it was not registered, sale deed was not registered, my lord. Many encroachments have come. Many people have opened their restaurant. Some public offices also have been opened. Some institutes have been opened. And the district administration knows about this. We have represented, we have informed them about it. So therefore, we have stated in para 34 clearly about them, and we have annexed the photographs also so as to bring it to them.
Take 2 weeks time.
Yes.
File your reply.
Perhaps that will be
23rd March. 23rd February.
Both the matters, my Lord. Obliged.
Item number 2, IN number 113 of 2022 with OLR number 126 of 2022.
Your Lordship, the arguing counsel in this case, Mr. Prashant Sinha, his father passed away, so this may be heard next week.
Next week he'll be there?
Yes, sir.
After 2 weeks?
Almost 2 weeks.
23rd.
Obliged.
Serial number 87, company petition 17 of 2003. Item number 1, IN number 16 of 2023, order 12 of 2023.
This interrogatory application has been filed on behalf of the BIADA for a direction of Leonard OL to hand over the position subsequent to the spot auction, my lords.
I filed a report. As regard to their property, we have proposed the confirmation of sale. Actually, its offer price was below the valuation. The valuation is for 15,000. BIADA,
which one?
Their property is Viharika Sales Center.
This premises was rented to this company under liquidation. It was a rental premises given to the company, and since 2015 it was sold. And now, pursuant to directions of the Supreme Court, that spot auction has been done. Whatever materials were there inside, now it has been, my lords.
Your OLR report is 12.
Yes, regarding to this.
It was auctioned on 9/12/2022.
Para 3, my lord.
You are asking for draft sale notice.
It's a fresh sale for others. There is, my lord, 5 centers in different places. For their asset Viharika, BIADA has offered, since no purchaser has come forward for that asset. Even BIADA is below 5,000. The valuation is for 15,000.
It was all old stuffs, my lords. There was useless things. Nobody was there. Even the BIADA has to come forward, my lords. Since we wanted the possession, my lords, because this premises is sealed since 1995. My lords.
So what?
So, my lords.
We keep it with us.
My lords.
If they offer 15,000, then.
We have already offered, my lords, 10,000. That has been accepted, my lords. So,
what essentially the OL is asking you is what? Goodwill.
My lords. जो पुरानी टेबल कुर्सियां हैं वो सब यूजली कोई काम की नहीं है वो सब चीजें.
You would be then asking for the rent also for that period?
Lords, in this we have
this
not.
You are not, then later on you will ask for.
They may forego, my lord, as per norm. They have to forego.
We have forgone, lords, because we have not claimed that.
Then, my lord,
otherwise, my lords.
This OL report, OL has submitted a report pointing out that spot auction of sale of Viharika Sales Center, Udyog Bhavan Patna, has already been conducted in favor of BIADA for a sum of rupees 10,000.
Yes,
although the same is below the price. Fixed, minimum price fixed, namely 15,000, the OL submits that the BIADA, which has given the premises on rent to the company in liquidation since?
It was given, lords, way back in 1980, lordship.
1980, has also not been paid any rent for the premises. Having noticed the above, and taking on record BIADA council statement that the rent shall be forgone.
May not be
you then you file your reply. Otherwise, we will treat that rent as consideration apartment, because we can't auction it less than what we have already fixed.
Lords, then I'll have to seek. Since it's a government institution, lords, I cannot.
All right. So we'll keep it next week.
Yes.
As it is, to take a session. That is the only way, otherwise I am not going to approve this 10,000.
So then, Lords, I will seek
My lord,
instruction.
regarding other asset, may kindly.
एक साथ ही ऑर्डर पास करेंगे
Yes.
तो OL कोड तो एक ही।
Serial number 88.
Any very urgent matter. I have to.
इसको नेक्स्ट वीक रखते
कौन से सभी
जो ऑर्डर देखना था पेंडिंग ऑर्डर जो देख के उसका 2010 के बाद जो कुछ हुआ नहीं ऑर्डर ले लेंगे इस तब लगा के लाएंगे
कौन सी
Disposed of Supreme Court did after praising the material on the record, the Supreme Court did not intend to interfere in the matter, but since so-called notice was issued, the appellants were given liberty to file the reply in 1 month.
Serial number 85, company petition 11 of 2002.
When was this order passed?
11/4/2017.
देखते हैं इसके बाद जवाब आया कि इसका प्रिंट आउट निकालिए। It is लिखिए। It is informed
89 pages.
by the registry that the civil appeal number 292/2007 stands disposed of
11/4/2017.
White order dated 11/4/2017. The order passed by the Supreme Court be placed on record so that further orders may be passed. Next, list again after 2 weeks.
Lord, you may mention, my lord.
Yes.
This item number 89, 92 and Lord 92. Next week I am not here, Lord, say your loss is fine.
All right, is all matters on 23rd. Distribute कर देगा 23rd और आगे
छोटा सा हुजूर आइटम है
पढ़ाते जाएंगे 3 घंटे
90 वो क्रिमिनल में वो एक्यूज आया 317 का पिटीशन स्टेटमेंट ऑफ अफेयर्स फाइल करने में डिले हुआ था पिछले बार कहा गया था कि उसको कंडोन कर दिया जाए नाउ वी हैव डन ऑल दी थिंग 2 आदमी एजेड
कितना फाइन कितना बताएं
अभी तो हुजूर के बड़ी गरीब आदमी सब है 2 बूढ़े आदमी बुजुर्ग है उनको बंगलोर में है थोड़ा सा दया किया स्टेटमेंट ऑफ अफेयर्स 2009 में पास हुआ बाइटिंग अब 2010 में पोजीशन ले लिया उसके बाद रिकॉर्ड हम लोग को मिला फाइल कर दिया
7 years delay
मैंने
7 years 13 years he was fighting all along before this one in court
all records
but
get there
has the statement of affairs been filed
yes
after
2016 we had already
after delay of 7 years and more than that
nothing has happened thereafter
and yesterday only they have today only they have signed also
no that was because your point
submit your report on the next date we will keep it on next date the
तो वही 23
accused
को
is present